What's up, everybody? Welcome back. Alec Baldwin's trial is over. We're going to react to how this happened and how, looking at it back with hindsight in this last day of trial, where the clues were, where the signals are, where it changed in the judge's mind. I think there's a very clear moment where it changed in the judge's mind, and then it was just downhill from there. And so many things happen. The prosecutor takes the stand. The other prosecutor resigns. The defense attorney looks befuddled a few times, and Alec Baldwin ends the day crying in his family's arms as he walks away a free man. And whether or not you think he committed a crime, we'll talk about whether or not the right thing happened in court yesterday for our judicial system, our country, and how things are supposed to go to promote the interest of justice. So hit that like button if you guys haven't already. Get ready to ask questions. The voice may seem weak, but the heart and the will are strong today. So let's have an enjoyable live where we learn about the law, talk through this trial, and try to understand what happened yesterday. So the very first thing that happened yesterday where I was like, wow, maybe this will be something big, is when the defense attorney gets up and says he has evidence that the prosecutor was potentially signaling witnesses on the stand. And some people were like, hey, listen, everybody preps their own witnesses. It's no big deal if she leads them a little bit, thing like that. Okay. But that's not what he's saying. He means when they're getting crossed or telling them no, or putting up a finger or whatever it may be, she was signaling which way to answer, which is an absolute no, cannot do. Everybody knows that. But the remedy for that is something like a reprimand, like, don't you do that again, Miss Prosecutor. But it was just the first step in a bad day for Miss Morrissey. So let's take a listen to how the defense explained it first thing in the morning.
Sort of inbound emails that I don't obviously read everyone or take everyone seriously, but I got one last night that indicated that the cameras are catching Miss Morrissey signaling witnesses while they're on the witness stand. And I really
did you look to see if that was true?
I was sent a photograph that concerned me, and I felt obligated. And like I said to the court, I try to not make these issues. This is a high pressure case. I've been in many. There have been more issues in this case than I had ever seen in all of those cases combined. And so
So again, sometimes that's hyperbole from defense attorneys. This is where it can really matter what your reputation is as a defense attorney. This is where it matters if you're a former prosecutor, I believe. People may not admit that, but I think former prosecutors that are now defense attorneys get a little more credence because they've had to deal with these issues. We know what it's like if we've prosecuted cases to turn over evidence, to dismiss cases, to not file charges on cases, to talk to a supervisor. We know what that's like. And so it's a little bit, you get a little bit more credibility, I think. And that's why you will almost always hear a defense attorney who has been a prosecutor before, myself included. I'm not saying I don't do this. My dad all the time. Tell the judge, make sure everybody in courtroom knows they've prosecuted cases so they don't think you're just a slimy defense attorney, which they think a lot of us are now anyway. But you get a lot more credence. And the judge even asked him, did you look at the picture? Is it a legitimate complaint or is it some BS from the internet? And he said, it was concerning when I saw it. And this is just how the day is starting, okay? No dismissal, no fireworks yet, really. Just more problems on this case than I've ever seen, Judge. And he's a big shot, New York City lawyer to the stars. And he has said multiple times, I've tried cases all over the country and all over the globe. This is how it's done. And he says that in this involuntary manslaughter carrying 18 months, which nobody wants to go to prison at all, one day, 18 months, but he has handled much more serious and severe cases. And this is the one that's had the most issues in it that he's ever seen.
Sort of at a loss, but to bring it to the court's attention. So I've asked them to print me the photograph that was sent to me. I can't just continue to give the benefit of the doubt on every single thing that's occurred in this case. I just can't. And so I'll be turning that into the court. And I would just say, at every turn of this, right, it's from the original case. It was, I understand and very much respect the court's rulings on everything, frankly. The grand jury, survived, and there's no remedy. I get that. And they destroyed the gun and we have that hearing and there's no remedy. And I get that. And it's just at a certain point in the Brady disclosure.
I did give you a remedy, but okay.
Well,
I didn't give you the remedy you wanted, but yes.
fair enough. But so one might say not a remedy given all of the circumstances that has a meaningful impact at this trial. And so, and then we had the Brady disclosures, and I could keep going, and I'm not going to because we have limited time. But there's just never been any. It's just, I don't know how much of it can happen with it.
Okay, let's do this. Where's the picture?
I'm having somebody print it.
Okay. All right. I am aware of what you're saying, but look, first I have to see the picture. Okay. Now let's go to the arguments of
Yes,
this.
sir.
Okay.
All right, so he gave us a little preview of all the things that have gone wrong, right? The speaking objections, signaling witnesses, so as people are saying it's too fast. All right, I'll slow it down a little bit. I mean, I usually do 1.5 speed, but people talk fast in this one. We got a lot to get through, so it's definitely going to be more than an hour. So everybody get comfortable. But the destruction of the gun during testing, and then he mentions the Brady evidence. Okay. And the Brady evidence, he just kind of says it. We've heard about the Good Samaritan stuff, and they're about to get into a bunch of arguments about Troy, whatever his name is, the Good Samaritan that comes in and gives the bullet and says, or the ammo and says, this is evidence in the Rust case. And the defense makes arguments that it should be dismissed over that. And the state argues, kind of like she did to the jury. And in my opinion, she did a good job arguing in front of the jury that this was Del Reed's buddy trying to help Hannah Gutierrez. He didn't like Seth Kenney and he was trying to pin it on Seth Kenney. Which again, it's really funny, ironic more than funny, that when I was watching it in real time, I was like, oh, remember we all were like, I thought that was going to be a big deal. And then we were like, oh, I guess it wasn't really that big of a deal. The prosecutor handled it perfectly, which is why this is all even more frustrating. Sometimes prosecutors make the easy things hard. We are lawyers. Our job is to explain things, to discuss facts and explain how they prove our theory. And all you have to do is turn over that evidence and that information when Troy Tresky comes into the police department and turns this over. You disclose it to the defense and you make the argument you just made in front of the jury that a lot of us were like, oh, we thought it was going to be a big deal. Then it didn't feel like as big of a deal. But if you don't turn the evidence over, if you don't disclose the evidence, you have now created an insurmountable problem. And it may not even be something that's dispositive. It may not even be exculpatory per se. But if it's potentially exculpatory, if you knew you should have turned it over, if you and law enforcement intentionally did things to bury or try to hide it, or try to never let it see the light of day or the defense ever to see it, you create a situation that we're about to watch unfold. And there's so much of that we know now, and looking back in hindsight to this day of court, we did not know. So it was kind of just my notes make me laugh a little bit, how I just kind of write one word. Defense argues again, about the Good Samaritan stuff, as if it's no big deal, because it seemed like it had all been turned over, or at least most of it, or they were remedying that. But then the judge says that she's going to order the state to provide the supplemental report. I was like, well, that's not good. If the state hasn't turned over the supplemental report that they have. And of course, the whole time Morrissey's like, I didn't know about this. I've never seen the report. I've never seen the body camera footage, which is coming later. But when the judge when the judge told them that they had to turn this stuff over, I remembered back to when she told the defense, too bad, I'm not taking this stuff out because you were late with the redactions. It should not have taken you this long to come up with the redactions. And she's like, so the remedy is, it's coming in. I don't care that the delay was only 2 days. And I was like, wow. I was like, I don't know if I love it, but I love that a judge that can make a decision. So knowing that she already did that and did it against the defense, my ears start to perk up a little bit. And I'm thinking, This isn't looking good. But at this point, it's very clear that she wants to continue going forward with this trial. And one of the things she did, which I also thought was very unusual, was she steps down from the bench, puts on gloves, and starts looking through these bullets, ammo, rounds, whatever you want to call them. She starts looking through them herself. She is doing her own investigation at this point because she wants to see, was this really a nothing burger? Was this really obviously nothing the defense could ever use that could ever be argued to be exculpatory? Was this something that was within the state's discretion? Or did they bury relevant evidence the defense could have decided to use and argue in their case? And she starts to do her own investigation here. We're going to watch just a little bit of it, but this is all building on what happens later.
Cool.
It's silver primer with brass primer, silver casing.
Okay, got that. Okay, 1 SIG 45 Colt. All right, and then 10 Starling Brass 45 Colt. All right, so do we have the microphone close by? Or can you pick this up? Are you picking it up? My question.
We've got one here.
All right, so point out to me, let me ask you this. Did Ziegler test?
This is not as unheard of. It's so funny. It's like we got to rank or draft the most unheard of things that happened yesterday. This would be on the list, but not at the top of the list. Judges don't usually put on evidence gloves, open it up, ask a witness questions in a hearing, handle the rounds themselves, look at them with their own eyes, sort them all out, and then go back and sit on the bench. It happens. I've had a judge come down and handle a firearm before in a case, which is interesting, but very unusual.
Ziegler tested the rounds in the Hannah Gutierrez case, correct?
Yes.
He didn't test any further rounds after the Hannah Gutierrez case?
No.
Okay.
So this is also important. The judge is so smart. And at the time I was like, okay, but she's like, the expert tested rounds, FBI tested rounds prior, but he hasn't tested any rounds since. And what do we know happened since? Rounds were turned over to law enforcement that the person who turned them over said, this is evidence in the Rust case. Something to that extent. And so this witness is confirming those rounds were never tested by the FBI. Now, why were they never tested? We're going to find out. I'm glad you asked.
In the Hannah Gutierrez case, can you point out what?
Just keep an eye on the defense attorney and his facial expressions, because he's like, what is going on? And he's not doing this for the jury. I don't even think he's doing it for the cameras. I think he is literally like, this is crazy. Like, this is so unethical. And I got to be honest, lawyers can get on soapboxes and feel pious. I feel myself sometimes being like, I am so offended at this injustice. And it may seem weird, but we dedicate our whole career. We fight every single day. We have stressful jobs. It can be miserable. People hate us sometimes. But like, we cannot believe sometimes when lawyers, judges, law enforcement do things that are so blatantly unethical. So I believe these are just natural reactions from him. I really do.
Gutierrez case? No. Okay. In the Hannah Gutierrez case, can you point out what types he did test from here?
I'm uncertain what types he tested.
This is a witness testifying, Ms. Morrissey. Please stop.
And how about that? So 5 seconds ago, the defense is like, Ms. Morrissey is signaling witnesses. She's trying to affect their testimony. The judge is like, okay, get me the info. The judge is asking this witness questions, and Morrissey pipes in to try to tell the witness what to say or affect this testimony. The judge is like, chill. So this is another indication that the judge has had about enough of these shenanigans.
This is a witness testifying, Ms. Morrissey. Please stop.
We sent all of the.
All right, let me ask it a different way. Do you recognize any of these types of bullets to have been gathered on the Hannah Gutierrez, on the Rust set?
The Starline brass with silver primer are similar to what was collected on the set.
And everything.
So there's an honest answer. They are similar to what was gathered from the set. And this is a really good question. So you say off topic, Bass. It's not off topic at all. A lot of people have this question, and it's a good question. Kind of off topic, but why so much focus on ammunition when the trial had nothing to do with it? So again, this may be good prosecuting and good lawyering on the prosecutor's part that some people think this trial had nothing to do with the ammunition. The defense, I think, would say maybe not everything to do with the ammunition, but it absolutely was a vital part of this case because Alec Baldwin had no reason to believe that there was live ammunition on the set. And the reason is it all kind of looks the same. You can't tell. You could shake it. You could look at it. And even if he would have checked it, he wouldn't have known. And he was acting as a reasonable actor would in similar circumstances. That was their argument. I'm not saying I believe it or you have to believe it, but they were absolutely arguing that the ammunition was so important because that's the failure that caused the death. And there is some good arguments to that, right? Because actors in all movies, like they argued, pull guns, point it at people, pull the trigger all the time. So that is actually reasonable, is what the defense was arguing. It's reasonable to point the firearm and pull the trigger. What's not reasonable is that live rounds would ever be there. So they were making ammunition part of this case, and the jury was going to have to decide that. But I get and I understand, I think the state was trying to focus more on firearm safety, what Baldwin did. But it's not up to the state to decide what the defense is going to argue. It's not up to the state to decide what's relevant to a defense. It's up to the defense. And sometimes the judge if there's an argument. But that was a great and timely question, so thank you. All right. Let's get back to a little bit more of this exchange.
Thing that was collected on set went to Ziegler.
Yes.
All right, thank you. I don't have any further questions, but I'll certainly allow him to talk about it. I don't know if you want to be there with her or what.
All right, so the defense does have some questions for her. They argue it was hidden from the defense. She gets mad because he keeps calling her investigator and she's a crime scene tech. She gets annoyed when he said she vouches for Kinney, but he is definitely making accusations. Let's go ahead and listen to a little bit of this exchange, okay?
That he had evidence that the defense wanted him to use that he no longer wanted to hold on to.
Okay, let's break that down for a second, right? Mr. Teskey isn't involved in your meetings with the prosecutors and Corporal Hancock's meetings with the prosecutors up until the trial, was it?
Not that I know of.
Okay, so doesn't it make sense that he would have seen the trial on television, been completely outraged at what he was watching, not trusted law enforcement, and then walked it into the precinct? Doesn't that make sense?
I do not know what would make sense to Mr. Teskey.
Okay, didn't he in fact tell you, I don't trust Miss Morrissey and the prosecutors?
He did not state that to me.
He didn't on your oath? You sure about that?
I do not recall him stating that.
And he did a lot of this. You sure about that? You sure about that? As if he has something to prove otherwise. And I don't know, it could be a scare tactic, things like that, but it's really interesting. Ashley said, just curious what Stephen Baldwin is wearing in his ears. Much love from Melbourne. So some people that have hearing impairments can get certain things. They can bring in their own. The court can provide them. That'll just amplify it in their ears and make it easier to hear. Roya said, I'm late, so he basically just got away with it all. So we'll talk about whether or not that's how I would define it at the end. If you define it that way, that's possible.
So he turns this round in, and you, when he turns it in, obviously recognize it as Starline brass, nickel primer, Colt 45, correct?
Yes.
Okay. So it's not as if he came in and just turned in a bunch of shells, right?
He did turn in a whole bunch of shells.
Okay. But he didn't just turn in shells, right?
He turned in multiple different 45 rounds.
I'll ask the question a third time. He didn't just turn in shells, did he?
He turned in multiple 45 rounds.
Including rounds that matched the round that sharpened sections, right?
Again, I wouldn't use the word matched without further analysis.
And the reason that we don't have further analysis.
Okay. She wouldn't say a match without further analysis, right? And that's exactly, and this lawyer, gotta just give him credit. He's listening when the judge is asking questions. The judge asked those questions before he asked these. Did you send any of these away to Ziegler to testify? Post Hannah Gutierrez Reed? No. She says, I wouldn't say match unless we do the testing to say they match, because ipso facto, you can't just tell if they match by holding them or looking at them or shaking them, which she has testified to in the past. So he follows up with the perfect question. Well, why don't we know if they match?
That's correct, Ms. Hutchins, right?
Again, I wouldn't use the word match without further analysis.
And the reason that we don't have further analysis is you all didn't send this to the FBI for further analysis, did you?
We did not.
Right? Because if you had, it would have potentially proven the fact that all along this ammunition did come from Seth Kenney. Isn't that true?
What I was informed of by Mr. Teskey was that the ammunition originated from Joe Swanson.
And then went in the green ammo can to Seth Kenney.
I do not recall him speaking about a green ammo can.
Okay, well, let me ask you this. The other thing that you're saying, I took you at first to be saying, well, it's just a bunch of ammunition, and now we've gotten to the point where it's actually the same type of ammunition. And then you've also stated in your testimony that it's like, well, there's just this guy, Troy Teskey, that just walks into the office like it's random. When really Mr. Teskey and his involvement in this case was very well known to law enforcement, correct?
I had never heard his name before.
Okay, but he came in and he said, I'm here to give evidence about the Rust case, right?
He stated that he had evidence the defense had wanted and he no longer wanted to hang on to it.
Well,
and he
That's just not true, by the way, which again, hindsight, he absolutely connects it to the Rust case. And now I wasn't sure if we were going to watch the body worn footage just because of timing, but I think we should watch it because it was very clear what case he thought this evidence connected to. And they're acting like it was kind of unclear. And she's the one he met with. And she even tells him she's intimately involved in this case. And it's crazy to know what we know now and how different I felt when I watched it and listened to it originally. Did you guys feel the same way? Like, did your perception completely change? And Amber, I agree with you here.
he was the one using the word evidence.
Okay. You said to him when you met him down at the first floor of the precinct, you were called because you were the person in charge of the evidence, the CST, right?
Yes.
Okay. And he said, thank goodness it's you. You're the perfect person to take this because you know all about the Rust case. And you said, I know all about the Rust case, right?
I don't recall that.
Do you deny that?
No.
Okay. And then he said to you, this ammunition was in Seth Kenney's possession. And you said Seth Kenney's law enforcement is well aware of Mr. Kenney, right?
I don't recall that.
So you take this ammunition on March 6th, right?
Yes.
The standard operating procedure for the Santa Fe Police Department says you're supposed to make your report within 24 hours, right?
Correct.
Okay. So tell the court, did you make your report within 24 hours?
I'm fairly certain that our SOP is that evidence should be submitted within 24 hours. I'm not certain on when the reports are supposed to be submitted.
So do you want to take your answer back? that you
Yes, I
gave a minute
do.
ago?
I apologize. Yes.
It's never a good thing when you're on the stand taking your answer back. Multiple witnesses have already done that. And I don't even think this is the last time she does it.
But we can enter that SOP into evidence. In this case, many times, there are police reports that are done the same day that the incident occurs. Can you agree with that?
Yes.
Okay. How much longer after this revelation did you do your report?
I believe it was. I apologize. I can refer to my report to refresh my memory. Oh, I have nothing. I believe it was the following month that the report was made.
Yeah, it was approximately a month later, right?
Yes.
Okay. What happened during that month? CST pop.
To be fairly honest, I went out of town to visit my dying mother.
Okay. I'm sorry about that. I'm sorry to hear that. Were you out of town that entire month?
I don't believe it was the entire month. No.
Okay. Who was involved in the word choice in this report?
Myself.
You didn't have any input? Because this doesn't look like the same language you use in the other reports.
Well, on a normal basis, I don't have conversations with people involved in cases.
Uh-huh. But there was also other officers there that were aware of this. Corporal Hancock was aware of this, correct?
She was notified about it, yes.
Okay. And so was your supervisor who was there with you, correct?
Yes.
So you're not telling me in this court that you had no input at all in the drafting of this document, are you?
It was reviewed by my supervisor. I don't believe any corrections were made to it or
The reason he's asking is because he's about to we read a very strange line in the report.
requested by him.
You know, it's just, there's a funny sentence in it. It says, and it's a sentence I've never seen in a police report. You tell me if you've ever seen this in a police report in your entire career. It says, it should be noted that this is not actual evidence from the death investigation collected by SO detectives.
You are not reading my section of the report. You are reading.
So I could argue either way on this. So yes, that is weird, but technically the qualification and the line at the end collected by Santa Fe County Sheriff's Office personnel kind of makes it true that it's not evidence that they collected from the set. But why put that in there, right? They're definitely trying to downplay this. Make sure everybody knows this is nothing important. No need to look at this. Very strange.
What was written by Lieutenant Brian Brandel.
I was going to say, it doesn't look like you're writing. So the lieutenant writes in, thank you for clarifying that. I just got this report, as you know, right? The lieutenant writes in, it should be noted that this is not actual evidence from the death investigation collected by SFSO detectives. Did I read that right?
I believe so, yes.
Okay. In your career, going back to when you were at CST in Florida, all the way through the present, have you ever seen such a sentence in a police report in your entire career?
Not that exact sentence, no.
Yeah, me neither.
The judge doesn't cut him off when he makes those snide remarks either, which is also an indication to me. I'm like, oh, okay, maybe she's with him here. Maybe she's with him. Then Morrissey has some questions for her. And again, in hindsight, this is all just so interesting to hear these back and forths and the dance that they're doing. So there's an interesting question here. Crystal said, I was watching Law and Lumber last night and they stated they thought the prosecutor intentionally tossed the case. What is your take? If you mean Morrissey, this prosecutor, I completely disagree. If she was going to toss the case before they ever started this questioning, picking up on the judge's comments, or at the very least, after a sidebar we're going to point out in the future where I think everything completely changed, she should have just dismissed the case. The prosecutor can dismiss the case herself. She can drop the charges. It would have an effect on a further civil action we're going to talk about at the end. She does not have to put all this on the record. She definitely doesn't have to take the stand and swear under oath and answer questions. She definitely doesn't have to have the judge look at everybody in the courtroom and say, basically prosecutorial misconduct, this case is dismissed. She didn't have to go through any of that. If she wanted to toss the case, dump it, dismiss it. Prosecutors do that all the time. I dismissed a case in the middle of trial once as a prosecutor. And it was the right thing to do. And I'm glad I did it. And I never wanted to try it in the first place, not because he didn't commit a crime, because he did. But it was like the third trial I ever did. And it was a possession of marijuana case. And the entire jury box or venire, potential jurors, was like, I don't think marijuana should be illegal. Technically it was, but eventually we dismissed the charges in the middle of the case because it was stupid. So it happens. That's what she should have done. Okay, let's listen to her questioning here for a little bit.
Well, I'm asking the court for.
Well, we don't have time for this. So what I'm going to do, for example, like with Hancock, I'm going to have her get up on the stand and continue testifying about the case. And then this portion, just like you did with Popple yesterday, we will ask. You can call, move Seth Kenny up. You can move Seth Kenny up, but he's going to do all of his testimony if you're going to do that.
So what? Here's the only thing I'm trying to do, and I don't mean to be frustrating. The only thing I'm trying to do is make sure that if this court grants this motion to dismiss, that I have made a full record, and I am entitled to do that. So I am getting my witnesses over here so that I can make a full record on this issue.
Well, what's interesting to me.
Certainly doesn't seem like she's tossing the case, right? And then the judge is like, interesting now that you want to have a full-blown hearing, when yesterday you didn't even want to respond in writing.
Be quite honest, is that yesterday you didn't even want to do a written reply. You wanted to just give an oral response.
I never saw these. I've never seen these, and I never saw the report.
Mm-hmm.
I have absolutely never seen these until this morning.
All right.
I've never seen the report.
So ask questions.
And that's why I think everything has changed. She realizes there's a lot more than just what Troy Tresky turned over. And I think she's starting to realize this motion to dismiss may be granted. I need to figure out what I'm going to do. And did the judge make the incorrect legal decision, potentially file some kind of appeal? Then there'll be a double jeopardy conversation. And to me, it's not a good look. And it's not a good indication by the court for her.
Of this witness, and then you can line up your witnesses and I'll see, but we're going to go with Hancock after this.
So in a couple minutes, this to me is where I thought, and I posted on Twitter, oh boy, there may be a slap on the wrist plea deal or a dismissal when this is what the judge says first. Okay, we're going to listen to about 2 minutes. Then they go to a sidebar, and then we'll hear what the judge says after that sidebar.
With that, because if you're asking a witness, then we're going to have to pile them out of there, and somebody's going to have to line them up and identify what's this. Okay, so do you want them staying out like this, or do you want them in the bag? That's all. That's my question for the day.
I think they should remain vouchered, and they are open like any voucher would be at a trial when and if a witness is questioned about them.
Okay, so here's my question. If I put them back in the bag, they're all going to be commingled, and you may not recognize them, so you can cross-examine appropriately or examine appropriately. Okay, you're lay people. You have knowledge. I don't need to go into it. That's my only question. Want it in the bag or do you want it out?
So what I would ask is, let us quickly just photograph it, and then we'll ask CST Popple to put it back, but remain at the courthouse. That's what I would ask.
All right. Is that okay?
Absolutely. My question for the court is, are we going to complete this motion hearing?
No, we're not going to complete it yet. Okay. I'm going
And
to.
can-
We're not going to complete this motion hearing, okay? And why is the judge saying that? She's saying that because we need to push forward. We need to finish this trial by next week. Let's keep going. I don't want to slow this down. We'll do it early in the morning or late in the afternoon, but we need this trial to keep going. So no, we're not finishing this hearing right now. That was what she's saying right now.
Can you just give us an idea so that we can be prepared for how you intend to proceed with regard to the motion hearing?
I'm going to have Hancock come up. You're going to call Seth Kenny, and I don't know why we can't do Seth Kenny's testimony if he's coming. Did you call him as a witness?
Sure, he's being called as a
Okay, well,
witness.
you should be prepared to call him. So we're going to do both, and I'm going to hear both.
So we're going to hear from these witnesses outside the presence of the jury and then in front of the
Oh,
jury?
you're right about that. Thank you.
That's my issue.
Thank you for pointing that out. Well, other than telling the jury to leave for the and come back at 3, which I'm not going to do to them, I'm going to continue.
Did you hear what she said? Other than tell the jury to leave and come back at 3, which I'm not going to do to them, she is not going to send the jury away for a couple hours. This is 1:42 on the timestamp, okay?
The testimony, and he would. Well, you said actually. I'm now thinking why can't the jury hear this? They heard Popple.
I'm sorry?
They heard Popple.
Oh, absolutely. No, I'm not making a comment on whether or not the defense gets to bring this in front of the jury. I'm making a commentary on the jury doesn't hear our motion hearing, and I just.
Oh,
want
they're not going to
motion
hear. Okay, I'm going to take evidence from each of these folks. Do you have? Is this a problem? So, I don't know what I'm going to do yet. So this is why I want to do it this way. Okay, I want Hancock on the stand. You can question her about this issue. Okay, Seth Kenny comes. You're going to do all of his testimony.
All right, so this is basically 1:43. The judge tells her how it's going to go. We're going to keep going with this trial. Then there's a sidebar. Okay, I'm going to answer a couple questions. The sidebar is about 10 minutes long. Meg R., what do you think this means for Hannah Gutierrez's retrial? So I have a little bit of that to talk about at the end. I can almost guarantee her lawyer is going to file a motion for new trial, and he should win. Nighthawks, how wild is it that Morrissey's assistant prosecutor resigned while the hearing was in motion? Is that normal, abnormal? That's higher on the list of abnormal things, right? Than the judge getting down and handling evidence. Incredibly abnormal. And she did a full-blown interview for 15 minutes with Chris Cuomo that we are going to watch and break down at the end of this video. Gypsy, your thoughts about Miss Morrissey understanding Miss Johnson's resignation? We're going to dig into this when Morrissey's on the stand. It's a great question. Ashley, will she get in serious trouble for this? Does it tarnish her reputation? Definitely tarnishes her reputation. A bunch of people have similar questions. Emily asked, can she face repercussions from the bar? And Eric asked, could she face disbarment? So she could absolutely face repercussions or sanctions from the bar. I don't know that it would rise to the level of disbarment. I think we still need to find out more. I really think if the bar does some kind of investigation, if there's a complaint made, more information needs to come out about it. But it is possible, and it is the type of thing you can get sanctioned for if you hid evidence, obviously. Salma, how can this be exculpatory evidence when there was no chain of evidence control? It doesn't matter. If I bring something in and I say this is the firearm that killed this person, you test it, you try to confirm it. If you can, it's evidence. And you explain how it got there. And the defense gets to say, well, they didn't have it for 2 years. It could have been doctored. It could have been messed with. It could have been planted. And it's up to the jury. So evidence can come in late. Good Samaritans can turn in evidence. Evidence does not have to be gathered from the scene and kept in the police station for the entirety of the case. Miss Bodette, is defense obligated to disclose Brady issues ASAP? Defense has discovery obligations as well. It's not the same though. Like they don't have to explain to the prosecution how they may use a piece of evidence as exculpatory, but they do have discovery obligations as well. Gunther, so this evidence was placed in a separate file, another bad view for the legal system. Have you ever seen that in other cases? Thanks. What's interesting is, how do you find this stuff out? My guess is this was such a friendly witness to the defense that he told them all of this. Maybe there's somebody in law enforcement that was a whistleblower to the defense, because I don't think they had these supplemental reports or body-worn camera. They said they didn't. So sometimes defense attorneys may never know if this happens, which is the really scary part. Can Morrissey face perjury for stating the reason for Johnson resigning was due to hearing being public rather than prosecution was flawed. So this is better asked when Morrissey's actually on the stand, but I'll explain to you when that happens that she says, I believe it was something like, and when you couch your answer like that, it's harder to convict somebody of perjury. Our head's going to roll over this. They're special prosecutors, so they don't technically work for the prosecutor's office. So Morrissey can't be fired from her own firm. But will the bar step in or something like that? I don't know. Miss Sharon said, who exactly is Troy Teske and why would he have Seth Kenny's ammo? So he's a guy in the business. He's friends with Tresky. He's friends with Thel Reed, friends with Hannah Gutierrez. He's in the business. He stores stuff. He's former law enforcement. So he's just kind of in the mix. Brady can be exculpatory or impeachment, right? Because this is impeachment of a lot of prosecution witnesses. Yes, but not just exculpatory, but potentially exculpatory and potentially impeachment. If the defense can find a way to use it, you've got to turn it over. All right. So we do this sidebar, right? And then we come back and listen to how the judge's tone has changed. I'm not sending the jury away till 3:30. We're continuing this case. Just ask them questions in front of the jury. We're not going to waste time. That's what the judge said literally 10 or 11 minutes ago, real time. And now after a sidebar, this is what she does. Jury coming in.
All right, you may be seated. We're on the record. Jury, thank you for coming in. I'm going to recess you for the day. I'm sorry. Trials are fluid. It's not something we predicted. Okay. So if you all can return at 8:30 tomorrow morning. Monday. It's been a longer week than usual. Okay. So Monday. Okay. So have a great weekend. Please don't talk among yourselves or anyone else about the evidence received here in court. Don't read any accounts. Don't do any research. Don't go on Google, et cetera, et cetera. Okay. Thank you so much for your patience. Appreciate it.
So she sends him home, which is when I'm like, uh-oh, big stuff must be happening because judges don't like to waste half a day. And then when I felt most confident it was over is after we have all these breaks, we finally come back to the courtroom. And what happens? Morrissey makes this statement.
And looked at the having conferred and looked at the evidence, it is the perspective of the special prosecutor as an arm of the public that all of the issues related to the defendant's motion should be heard by the court and they should be seen by the public. This is a public issue and a record should be made. And we are here to do that.
Ms. Hancock?
They're a public arm of the court. There should be a public record. The public should be able to view that. So the other comment about Law and Lumber wanting her to put these witnesses up for everybody to see, maybe throw them under the bus and protect herself by testifying. She has a very strange way of doing things, I will just say. I don't get why she wouldn't just dismiss these charges. Prosecutors realize that they can do that. They are supposed to do the right thing. And when they realize they've screwed up or they can't prove the case, whether it's Massachusetts or New Mexico or Florida, drop it. That's what you should do. Somebody also said, if you want to see Erlinda Johnson walk out, 441. Let's see, 441. All right. So here she is walking in, green shirt. And then we're going to see her walk out, I guess. There she is. She runs out. Yeah, that's not where she left, because if you watch her walk in, she's got, her purse, her bag, and then she runs out. I think she comes back after this. But either way, eventually she does walk out and she's done, and we'll talk about that more later. Okay. So then we get to the hearing, and Seth Kenney talks about where he got the live ammo, how he stored the live ammo, all this stuff. But let's talk a little bit about, or listen to him describing the interaction between him and Troy Teske about when Troy came in possession of the ammo.
These are the 4 different types that I could find. And I reply, Yep, it's evidence in the accidental death.
And hang on, we're going to stop there.
He says it's evidence in the accidental death. So can we really blame Troy Tresky for thinking it is? If this guy who's intimately involved, who may have some agreements with the prosecutor and may be testifying for them, is it really Troy Tresky's bad to think that this may be evidence in the case? I don't know the answer to this, LH. It could. A lot of times prosecutors and law enforcement want to make sure they are right over anything else. And that's what we have to hold them accountable to and make sure they don't get away with.
Why did you think this was evidence in the accidental death?
Well, I think at that point, without having seen the evidence photos and knowing, the only thing I did see was Detective Hancock shared with me a black and white 8.5 by 11 piece of paper with some pictures on it, and I saw Starline brass, and it was it was the nickel primer Starline brass case, and I hadn't really connected the dots that the gentleman that loads these hasn't had nickel primers in 10, 12 years.
How do you know that?
Well, he says he only used Winchester primers.
No. Did you speak to him? How
Yes,
do you
yes,
know
I
that?
did.
Okay.
Right after Hancock and I
So
got.
basically what he says is after saying it's evidence, after talking to more people, looking at more things, he realized it's not actually evidence. Okay. In the case, that's his opinion, which is fine. But like, here's the point. And this is why I want to try to help us think about this the right way, right? He was intimately involved in this case. He's a firearms expert. He thought it was evidence in the case. Later, he thought it was not. But if he thought it was, Troy Tresky thought it was, even law enforcement maybe thought it was, do we really not think there's a chance or a possibility that the defense may think it's exculpatory or impeachment evidence? Because we also have to remember in all of this, and in the Hannah Gutierrez retrial, again, you realize we were like a day into this trial. So for us to say the defense wasn't going to argue this or this wasn't part of the case, we can't really say that. But the whole like sabotage and somebody planting this or wanting to make Alec Baldwin or Hannah Gutierrez Reed or somebody look bad, that was part of the case. That was a potential defense. And if you have ammo, you can connect to Seth Kenney. Maybe the defense is going to point the finger at him. Did he sabotage this? And whether you agree with that theory or not, it would have been up to the jury to decide, was it sabotage or was it negligence? But that's not for you to decide. It's not for me to decide. It's for the defense to decide. You turn over everything, and a defense attorney and the defendant go through it together, and they come up with what arguments they're going to make. You can't just withhold things for them because you think it's no longer evidence, especially as a witness, let alone a prosecutor. Defense reads some text messages of him, cursing people out just to make him look angry or maybe make him look bad. Then Hancock takes the stand, and she says Troy Tresky came in during the Hannah Gutierrez retrial, not after. And she explains why she doesn't think this evidence was legit and why this is no big deal and no problem.
Do you have any idea whether or not this is related to the case?
Just by him saying it might be, but not in what context it would have been.
But you didn't speak to him?
No.
Okay.
It may be evidence because he said it was evidence. If somebody comes and turns something in and says it's evidence, you should probably at least investigate.
And is that the reason you were trying to reach him?
Yes, and to try to set up something where I could have a discussion or an interview with him.
And you want to have the interview because you want to see if it's tied to the case?
Yes.
So you call him twice, and does he respond?
No.
Do you continue to try to reach him?
I did try to reach him again. I believe it was the following week. I tried to reach out a couple times and never received a response back.
She's like, so therefore, we don't even code it under this case. We bury it because he didn't pick up the phone. The defense has more on that later and whether or not that's actually true and whether or not we can believe that. But what have we already heard from Popple? Did they really need to call him and talk to him more to figure out if this was evidence? Or could they have done something else? Could they have sent it to the FBI lab to be tested to see whether or not it matched what was on the set that they knew was on the set at Rust or what they gathered from PDQ because law enforcement did those two things? Send it off to the FBI, test it, see if it's a match. You don't need to talk to Mr. Tresky to do that, but they intentionally didn't do that. And I don't know if I'm going to play it or not, but the facts and context around I called him a bunch of times and he didn't answer is very sketchy. What's the federal law for all gun owners? I don't know what this means necessarily. JMass, in a world where the evidence was properly disclosed, what would the defense have done with it? Would it have mattered to the jury over the events surrounding the shooting itself? It could have. Was there a sabotage? Did Alec Baldwin act reasonably? Did the cops bury evidence? It's wild. I started watching this against Alex, and by the end, I was rooting for him. What punishment can we realistically see happen for the prosecution? So there can be sanctions. There can be remedies against individual prosecutors, but there can also be civil lawsuits. And somebody asked, can he sue for malicious prosecution? I believe he's got a pretty good case. He even threatened that before they filed the second time. So I think it's probably better than a maybe. Special K, how could this help Hannah when it comes in after her trial and actually hurts her case? It can help her in the same way that if the state was burying and the law enforcement was burying potentially exculpatory evidence during her trial and violating her rights. That's how it could potentially help her. And again, we're all saying it would actually hurt her case. I think there are arguments it could help her case. Was this Seth Kennedy? Was he sabotaging her? Did he hate her? Did he want to get rid of her? Maybe the jury wouldn't buy that, but the defense has to have the opportunity to make that argument. Trixie, good morning. I kept checking to see if you covered this yesterday. I watched it in real time and couldn't wait to hear your perspective. I appreciate that sometimes your opinion differs from other law tubers. So I like watching and listening to some of those law tubers when I can, but when I watch a trial, I usually watch it on something like this so that, I can get the timestamps and no interruptions and things like that. I was just doing a million things last night, hanging out with a bunch of friends for a concert that was canceled because the guy lost his voice, but your boy's here. That's just a wink, wink joke. But yeah, I like talking about this stuff, and I just love giving my initial reactions and what I'm thinking and what I would have done, and how this applies to situations I've dealt with, and makes it interesting and fun for me as well. So thank you for being here. All right, let's keep listening to a little bit more of her explanation as to why she didn't really dig into this.
So if you don't have a witness who will give you an interview regarding the items that they dropped off at the sheriff's department, how do you know that they're in any way related to the case?
I really wouldn't, because I didn't have a discussion with him.
Has Mr. Teskey ever returned your calls?
No.
Okay, let's just for a second think of other ways she could have confirmed. Call your boy Seth Kennedy that you've talked to a million times. Do you know Troy Tresky? How would he be involved? What does he know? Could have confirmed it that way, that he's actually legit.
Did you?
Or that he's just hates Seth Kennedy and buddies with Del Reed. Still, you would have confirmed his connection and potential evidence in the case.
Are you aware that the exchange between Mr. Teskey and the people at the sheriff's department that took place when you were in trial with me, are you aware that at least part of that was recorded on a body-worn camera?
I know now.
When did you learn that?
Today.
And have you had an opportunity to review it?
Yes.
Never given this, Your Honor.
I just got it. So
I just want the court to know. This is,
I can give it to them.
This is the newest of the revelations.
Did you hear him? So Morrissey asks her the question. The defense is like, we don't have this, Judge. This is the newest of the newest disclosures. So I think a lot of people thought this case was going to get dismissed, meaning the defense attorney, the judge, and maybe the prosecutor, before they even knew about this. And at this point, the prosecutor knows she's lost. So why not dismiss the charges? That would be my question to her. I don't care if you think Alec Baldwin did it. I don't care if you fully believe he did it. As a prosecutor, at this point, you know it's over. You know justice has not been served. You've got to dismiss these charges. Tracy said she heard that Bowles may have blown the whistle, which very possible. But look, the defense attorney once again is like, seriously?
So there's when Teskey comes into the station, it's being recorded on a body-worn camera?
I believe
The judge is like, seriously?
the defense did have it because they knew what Mr. Teskey was saying to Popple. That's the basis of the cross-examination.
Well, it's not. It hasn't been admitted as an exhibit.
Sure, and I can call Popple and have it admitted as an exhibitor. I can call Randall, but it's a motion hearing.
So anybody that thinks she was doing this as a surprise or to get, Hancock in trouble, no. She fully believed the defense already had it. She doesn't believe him. She says that's why you were asking those impeachment type questions to Popple. You were quoting stuff because you had watched the video. First off, my first point will be, it doesn't matter if you think they already have it or they've gotten it some other way from a whistleblower or Bowles or somebody else. You still have to disclose it and turn it over as the prosecutor. It doesn't matter if you think they already have it. You have a duty to disclose it. That's number one. Number two, this defense attorney's like, you're being shady. You're not going to accuse me of being shady. And that's why he stands up.
You want me to handle it? She's now seen it. I can give it to the defense.
No, I'm going to have the person that, whose body it was on. Let me ask you, in the meantime, while I'm listening to this testimony, can I have the exhibits from Popple that she testified about the bullets and what they were, when they went to the FBI? Her inventory of bullets. May I have those exhibits? I know there's a lot of them.
Sure. I think there are probably some also from the defense. So does the defense want to go through their file? Do you want me
I
to
just
do
want
it?
the ones that Popple testified off of, not any.
I don't
Are
remember
you
exactly.
looking for the one that I just highlighted? specifically?
No, I'm looking for the ones that Popple testified, she inventoried and had tested.
Are you asking for scene photos or no? Just the ones that she had?
He confirmed later, no, Judge, I did not have it. All right, we're going to jump ahead a little bit.
Yes.
Did you hear what Mr. Teskey said in the video regarding whether or not these came from the set of Rust?
He said that they were not from the set.
That's what he said on the video.
Yes.
Okay. And I'm happy to get.
He can't cross-examine off of this.
Sure,
so,
and I can get it to him.
well, you are going to give it to him, and this testimony, he can call her back up if he wants. But,
Absolutely. Sure. I'll pass the witness.
all right,
He's like, seriously? Jennifer, thanks for the super chat. I appreciate it. And I am doing more of this, okay? And we're structuring things in a way to do more of this, but I just like practicing law too much. So I don't think I'll ever stop. I like being in the mix. I like still getting, these real life experiences that I can bring to the table for this. So I appreciate it. I appreciate it.
I have some questions. Can you put back on that
Judge has some questions. I love when the judge has questions.
video of the text that Seth Kenny
Sure.
got from Teskey?
Sure.
Colt?
It didn't seem similar in the primer. It was different in the primer color. So
In what, why is it different in the primer color?
because the primer on
The
this,
judge is like, I'm looking at these pictures. Are you sure this is different? Because she said this was all different than what was found on the set.
the third one it's a brass color. The primers that came from Rust were silver.
Who's
So K-Rab, we'll see. I don't know. I don't think that that's correct. I don't think that's correct that he had the body cam footage in the supplemental report, because Morrissey said she didn't get that until now. So I'd be shocked if he had all of that. It's possible though.
these are, you counsel, you need to come up. Counsel, you need to come up. I'm questioning. You're going to need to see this, both of you.
I can see what you're showing her. I saw what you're showing her.
Morrissey's like, I don't care. Go for it.
I only see one silver here.
Right, but this is in reference to the live ammunition.
Look, you just testified. Let me just ask this. None of these look similar to the set on Rust,
To the live ammunition.
to the live ammunition on
Yes,
Rust.
ma'am. Yes, Your Honor.
But it still looks similar to what was on Rust.
Yes, yes.
It looks similar to these on Rust.
For the dummies, yes.
Yes, it looks similar to dummies on Rust.
Dummies, but not live.
Okay, I understand your distinction on
Okay.
that. But they still look
Once
similar.
again, because it looks like the dummies, not the live rounds, they didn't feel like it could be relevant. Not their decision. Very clearly, legally, black letter law, not their decision to say, well, because it looked like some but not others, we're not even going to turn it over because it can't be potentially relevant. I watched it from beginning to end, not necessarily live, and oh yeah, so many wild moments. So many wild moments. So knew about the ammo and didn't use it is different than knowing about everything that happened and then putting it under a different case number and doing all these things that you could impeach law enforcement with, right? There's two sides to it. There's the actual evidence, and then there's what law enforcement and the prosecutors did with it, right? And again, I don't really know what they knew and didn't know at this point, so it's hard to comment on that. If they file a motion for a new trial, we'll see. Azam, Peter, in your experience, is there ever a judge asking the question to a witness in the middle of the trial? Yes, but the jury's not here, so this isn't a hearing. Judges ask questions all the time in hearings, but you got to listen. Because if they're with you, you want to kind of repeat and dig deeper into what the issues they think are important, kind of like an appeal, an oral argument. 410,000 subscribers. Yes, everybody hit the subscribe button, please, if you haven't already, and hit the like button on this video. There's 16,000 people across all platforms watching, so hit that like button if you guys have not already on X. Hit the heart wherever you're watching. Thank you. Spiro's a dragon, Spyro. That reminds me of Step Brothers. Hello, Dragon.
Similar. That one, the third one from the left, still looks similar to dummies on rest.
Yes.
All right, thank you.
Can I have a seat, Joe?
Yes.
I may not even need the video right now, so we can start without that.
All right.
Good afternoon, Corporal. When you started investigating this case, you were investigating this concept of sabotage, that there could have been an intentional live bullet placed onto the set. Do you remember that?
Not originally, but later on, yes.
Okay, and obviously if somebody,
Let me just ask it.
Sure.
So they're not similar to the live rounds. That was not similar to the live rounds, but they were similar to the dummies on rest.
That's correct.
Okay. And the dummies on rest were tested with a live ammo by the FBI.
Yes, some of the dummies were sent.
Do you pick up what the judge is doing? She's very smart. And she's like, so you're making this distinction right now. Okay, fine. But when you guys sent all this stuff to the FBI, you sent dummies and live rounds, right? Right. Okay. Okay.
Some of the dummies that look like that one on the phone.
I couldn't say which exact ones were sent to the FBI.
Okay, but you just testified that looks similar to the dummies on rust.
Yes.
You didn't differentiate, and that some of the dummies on rust were sent to the FBI.
Yes.
Okay, thank you.
so
That's bad. Then the defense again gets yet another prosecution witness to agree what they testified to before was completely false. Another unusual thing that usually doesn't happen under oath on the record.
as you sit here, that there was 45 long cold starter line brass nickel in the courtroom today from CST Popple.
I just found that out today.
Okay, so you were here for this testimony in this courtroom. And let me ask you, Ms. Popple, the ammunition that the Good Samaritan, Mr. Teskey, the close friend of Hannah Gutierrez's dad, when that ammunition that he brought into you after the conviction, you still have it? Answer, yes. Question, you can bring it in here and you can show it to the jury, right? Answer, yes. And they can see for themselves that it does not match the live ammunition from the set of rust, correct? Yes. And that it is obvious. Just when you look at it, it is not. Yes. Do you remember that testimony that you were sitting here for?
Yes, I do.
And that turns out to be completely false, doesn't it?
You're correct.
Imagine just yourself, okay? For all you guys out there that are watching and listening, a lot of you have jobs as doctors, lawyers, law enforcement. A lot of you have jobs as teachers or as long-haul truckers or as nurses or as accountants. Whatever it is you do, stay-at-home mom, 18-year-old high schooler, college student, law student, whatever it is, unemployed at the time. Imagine yourself as a non-law enforcement officer taking the stand and being like, what I just said was completely false. That's the language he used that she agreed with. Completely false. I'd be like, I would have begged Morrissey to dismiss these charges, which is why, these wild theories that are being thrown out there, I get it. Problem is, a lot of this is coming back on Morrissey too. I'm going to jump ahead a little bit further. Again, she said she would have investigated the claims further if he would have picked up the phone.
Mhm.
You're saying that Troy Teskey made the statement to law enforcement that the ammunition matched rust.
Correct.
Where is that statement coming from?
In your own police report.
Okay.
I'm reading it.
So he does say your own police report. He corrects himself. And this is where you can tell. And if I'm him, I'm like, oh, the judge is with me, baby. Here we go.
Okay, so that's not my police report.
I didn't say it was your police report.
You just said it was.
No, I said in
Yes, you did, Spyro. Yes, you did. But that's okay. That's okay. You fix it.
the police report.
That's not my police report.
I didn't say it was your police report.
You just said it was.
No, I said in the police report.
Just as a point of clarification, can we?
Is this an objection or is she just talking?
Yeah, you gotta have an objection.
Is this an objection or is she just talking? Like, he's had it. Everyone's had it with Morrissey at this point. Not just us.
I said that no running things.
My
Speak.
request is that we correct the record with regard to Mr. Cyrus.
That is not an objection. What is your objection?
I want to correct the record. that
One
you actually
word.
stand showing you your police report.
He's corrected himself. A police report.
And that's why when you do that type of arguing and you do that type of stuff, you lose credibility with the judge. And the judge is like, you know what? He already corrected himself. When technically he was wrong. The judge knew it, by the way. She's listening because she said he corrected himself and said, hey, police report. You probably would have won that objection. misstatement of the facts. That's the objection, by the way. But the judge is so annoyed with how she's objecting. She's like, just sit down. He corrected himself. By the way, there's no jury. So it's a little different.
In your sheriff office's police report, okay?
I absolutely love a good pink iPad holder. I love it.
I don't mean your personal police report, but in your sheriff's office police report, right?
Okay, understand.
And not only does this police report come into the very same sheriff's office, correct? Right? This is your police department, right?
Yes.
Okay. Not only does it say live rounds of ammunition that he believed to be connected to the Rust case, right? You
Yes,
saw that, right?
yes.
Okay. Not only does he say it's the same batch that was at Seth Kenny's, right?
I mean, that's what it says there. I don't remember that statement in the video, but
Well, I'm glad you brought that up because the videotape, whatever there is that has also not been turned over, it didn't necessarily capture every conversation that Mr. Teskey had inside the police department that day. You don't know that.
that's correct.
And he is so right on that. When we get to the video, you'll see and explain why. So yes, she could be sanctioned. We'll see. And it could have an effect on Hannah Gutierrez Reed's appeal. We'll have to see kind of what they knew, what they didn't know, and how it all works out.
And the other thing that I wanted to mention at this point is it's not as if Mr. Teskey was talking to some random auxiliary cop that happened to be walking through the station. He was talking to CST Popple, wasn't he?
Yes, he was.
The same CST Popple that testified yesterday, right?
Yes.
That testified that everywhere in this case that she went, you went. Remember that testimony?
Yes.
Okay. She goes to the church on the day of the incident, you're there, right? She goes to the search of the truck, you're there. You go to PDQ, you're there. In the prosecutor's office, you're there. Trial prep, you're there. And that's who took this statement, right?
Yes.
It's pretty wild. So Jay throws out this hypothetical. If I go to a full service gas station and a guy fills my car with gas, I drive out to the lot, hit and kill someone. Is the gas guy guilty and I am fine? So what I would say is, this is not exactly the same analogy, but maybe a similar analogy, which I haven't had time to really parse this out, would be if the guy put explosive material in your gas tank and you drove up and sideswiped a car, which you're not supposed to do, and your gas tank blows up because of what the gas station attendant put in your car, and somebody else dies, who's liable? Well, you shouldn't sideswipe somebody. You shouldn't hit somebody with your car. So you have some wrongdoing there, but was it just negligence? It's a question. Did he know, or should he have known, that what he put in your car would blow up? And if he did know, and he had a duty not to put whatever he put in your car in because it was likely to blow up, then maybe he would be liable for putting that explosive material in your car, knowing that when you hit the gas, it could explode. I think that's probably a more similar analogy. Do we know how the defense found out about this evidence? No. We don't know if it was Tresky, if it was a cop, if it was from Bowles. Hi, Peter. Why with prejudice, unless because the prosecutor's non-disclosure and hiding info, the judge thought didn't have enough evidence to charge Alec? So with prejudice because we hold prosecutors accountable. I told you about a case we had in federal court. We went to trial, lost, won the appeal, went to trial a second time, lost, won the second appeal. Before it got to trial the third time, the judge had had enough with the FBI destroying evidence, saying things that was not true. A certain FBI agent, not the FBI as a whole, basically said he was not trustworthy on the stand in open court and threw it out. And that's after that defendant had been convicted twice. Dismissed it with prejudice. And she knows there'd be a double jeopardy argument at this point. The jury's been sworn. Alec Baldwin's been put in jeopardy. And she threw out the case because of prosecutorial misconduct, basically. So it wouldn't go anyway. Can you explain the special prosecutor title more, please? So basically, the special prosecutor just means not somebody that works in the office. Either, sometimes you can get a federal prosecutor, attorney general, or something like that, or a defense attorney, which these attorneys are defense attorneys, have them come in and prosecute one case specially because either there's a conflict in the prosecutor's office or you need outside people to do it. There's different reasons for it. But it's just not a normal prosecutor. That's a government employee. How would this affect Hannah Gutierrez Reed when her trial knew about it? Or will she just get funky business alone? We'll see. Again, I don't know what they didn't know. So we'll just have to see as it all comes out. Do you think Morrissey's defense background may have impacted some of her decisions as special prosecutor? Probably get back to the defense mindset because it's ingrained in her. She was a prosecutor too. So I don't know what, I think she wanted to win. And I think she wanted to get Alec Baldwin. And we're going to hear more of that when she takes the stand, which is coming up soon. All right, a little bit about how she shouldn't make the decision. as to whether or not this is exculpatory.
Had been related to Rust.
There was no way to relate this item to Rust, and the guys in your precinct telling you this is related to Rust, and you had spoken to him on speakerphone and you had gotten those text messages. There's no way to relate it.
Again, I didn't get a statement from him when he's dropping off this ammunition and didn't see it because I wasn't there when
Well-
he was dropping the ammunition off.
Well, your colleagues got a statement, didn't they?
Yes.
Right? It's not like he didn't give a statement that day. He sat in the precinct and met in a room with your colleagues and did give a full statement. So that wasn't true either, right?
I didn't know that until today that he had sat down with someone.
Okay. But now that you know that, now that you know that he gave a full witness statement, the story that the only reason that law enforcement couldn't possibly dream up a way to connect this to Rust and put it with the rest of the evidence doesn't work anymore, does it? Because he did give a statement, right?
I'm not going to agree with that because he said it didn't come from the set.
Well,
So
you keep saying that, but he's not. The point of this isn't that he literally snuck onto the set and took it back, right? The point is that he had the matching ammunition so that we could understand the source of the lethal round, right?
but again, I didn't know he had matching ammunition.
Well, but your colleagues did.
Again, that wasn't something that was told to me.
I understand your testimony, but given that all of the things we've just discussed about, wouldn't you agree with me that if law enforcement were to come into this court and say the only reason we couldn't possibly connect this to Rust was because he didn't give a witness statement, that doesn't work if he did give a witness statement? True.
Potentially, I'm going to still say that I wouldn't agree with that because I wasn't able to speak with him and how it would.
She argues back and forth with him over and over again. Then he goes through like, what phone did you call him on? Because there's no records that you actually ever did call him. Not great. Then the judge has questions. And she basically says, you can't really say if it's from the Rust set or not. And you knew this Baldwin case was going on, and you still didn't actually go check after the Hannah Gutierrez retrial. We'll listen to more of the judge's questions.
To my understanding, it was going to be put in evidence
Which evidence?
at the sheriff's office.
The Rust evidence?
No.
Why
just,
not?
Just as far in our evidence section in the sheriff's office.
And why was that determination made?
As to why
Who
it
made it?
was,
Let me ask you, who made it?
these were discussions that were had with myself, with the supervisors at that time, and then with the prosecutors.
Were you the lead investigator?
Yes.
Okay. And you said, and with the prosecutors.
Yes, ma'am.
Okay, so you all had discussions about what to do with what he dropped off.
Yes.
And you all agreed to put it in the separate file.
Yes.
Thank you.
Just very.
So this is why, if you're Morrissey, you're not just putting her on the stand and sinking her. You met with the prosecutors, you met with other cops. This was after the Hannah Gutierrez retrial, so Morrissey's on the case, and you all decided it wasn't evidence. Back to the defense.
Very brief follow-up on course questions. The defense requested, both through you and the prosecutors, to see all of the ammunition in this case, right?
Yes.
Okay. And obviously, and I know it's obvious, but I want to make sure it's in the record, we were not ever shown that, correct?
Well, I believe that you guys had a secondary evidentiary meeting with the sheriff's office that was canceled the day before the meeting was supposed to happen.
Look at the defense attorney shaking her head no.
Or an evidence showing, I'm sorry.
Okay, yeah, we were able to come for some showings and not others. But the reality is when we came for showings, you never showed us this evidence, correct?
I don't know if I can agree with you there because even on the first day that I was present at the evidence hearing, we didn't get through all the evidence that they wanted to see that day.
I don't know what questions this was.
Let me ask you something.
This is such a lie. You coded it a certain way. You were never going to show it to them. And then she tries to blame it on them because they had to cancel a meeting one time. She's one they should look into, in my opinion.
If
She
Ms.
seems to
Popple
have no problem saying this stuff with a straight face.
said it was not in the evidence viewing, would you disagree with her?
If
Popple was like, it wasn't even in the evidence viewing. Popple said some stuff that was frustrating, but at the end of the day, I think she was trying to be honest, even if she was trying to spin it. I'm not sure what's going on here.
ammunition, sorry, just want to make
If
sure I'm
this,
understanding.
if in the evidence viewing, would you disagree with her?
If this ammunition, sorry, just want to make
If
sure I'm
this,
understanding.
if what Troy Teskey dropped off was not in the evidence viewing because I can get the testimony, but they had a narrow. If Ms. Popple said it was not part of the evidence viewing, that you did not gather it for the evidence viewing, would you disagree with her?
I believe that we were sent a list of what they wanted to see. And then, Your Honor, the first day that we had done an evidence showing, we didn't get through everything.
That's not what I asked you.
And
Even the judge is like, can you answer my question, ma'am? And for her to say that the defense has to provide a list of everything you want to see, it's like, if they don't know it exists because you never told them about it, obviously it's not going to be on their list. Come on.
yeah, I understand what I'm trying to, then we had another day.
Pardon me?
We had a second day that was set up to
I
continue.
asked you if you would disagree that Ms. Popple said that it was not that it was not included in the evidence viewing, not whether you got to it or whatever, but whether when they said we want evidence viewing, Ms. Popple said it was not part of the evidence viewing.
I don't know if it was or wasn't.
Would you disagree with her is what I'm asking.
I really don't know how to answer
All right,
that.
Thank you. Redirect?
I mean, that's the judge saying, I don't believe you. I don't believe you. And I think Morrissey has a couple questions for her now.
I can't provide the video until she logs into this system.
You know, I don't even think the video is relevant. She did not view it until today. So you can look at it.
Judge is like, at this point, I'm like, I feel like the judge has just made her decision. She's like, do we even care what the video says? Well, I think you guys are going to want to see it. If you haven't seen it, we're going to watch it. It's not that long.
But do you have any cross-exam for her?
I just need to develop my record, so I need to get the video in. I need to get the video
You can
in.
Thank you, Brooklyn Basement. I really appreciate that.
The video in, okay? Are you going to get it in through her? Because I said it should come in from the person that wore the body
I
cam.
agree with you. He's here.
Okay, well, fine. So do you have any cross-examination for her?
I do. Corporal, as you sit here today, do you have any reason to believe that the ammunition that was provided by Mr. Teskey came from the set of Rust?
No.
Can I ask a question?
Sure.
When you say,
I got to be honest, Taurus girl. The answer to this question does not prove whether it was a crime or not to me, because again, I don't know the duty. But after listening to these trials, I do think there are ways that an actor wouldn't even know it was a live round in the firearm, especially if he wasn't being hypersensitive. Like if he just would have taken him out and shaken him, because in his head he's already assuming it's cold. So even if he would have checked it, I think it is possible for tragedy to happen, whether it was someone he loved or hated on the other side. Oh yeah, Lisa.
that there were discussions and the decision was made by all of you to put that ammo in a separate file, right? Is that correct? You said that?
She's confirming all of you guys, prosecutors, law enforcement, you all decided to put the ammo in a separate file. And in case you don't know what that means if I do a public records request for this file, I'm not going to get it. If I am a lawyer and I say, I want everything you have on this file. If Alec Baldwin got new lawyers and they were like, we need everything on this file, this would never be part of that. It's effectively burying it.
Yes, ma'am.
Was Ms. Morrissey part of that discussion?
Yes.
Thank you.
Let me give the court an offer of proof. And if Mr. Spiro wants me to, I'll testify under oath. Sure, absolutely.
Ooh, and that's where it is. If Mr. Spiro wants me, I'll testify under oath. And the judge is like, you are going to. I think the judge is more pissed off than Spiro. I honestly start to feel that way.
I'm happy to.
And I saw people being like, Morrissey's a G. She'd be happy to testify. It is never going well for you if you have to testify in court. I don't care if you're confident. I don't care if you're like, fine, I'll take the stand. It's never going well for you, confident or not. If it's your case, right? Like if I go testify in some other case, fine. But I don't want to be testifying in a case I'm actively litigating. That's not good.
I'm showing you State's Exhibit 16. How do you know that's related to the set of Rust?
Because
Okay, we don't need to listen to this. So now she goes through all these different pictures. Like this was taken from the set. This was taken from the set. As if nothing could be found not from the set of Rust, which we know is not true. And we know they don't believe it's true. That's what I'm saying. Morrissey is in on this. Because guess what, folks? What do we know? Where did they search outside the set of Rust where they gathered evidence for this case? PDQ.
collected during a search.
Did it come from the scene?
Yes, I believe that one did come from the church.
All right, let's jump ahead a little bit. But I hear somebody outside my door. All right, let's jump ahead to the body cam footage. All right, here's the infamous body cam footage. Let's see what we learn.
Lieutenant, so nice to meet you. Lieutenant, so nice to meet you. I've got some evidence. You need to do this out here? Because I should probably write out something. Like a chain of custody. Yeah, we would have a chain of custody there. So yeah, come with me and we'll go. That's my wife.
Are you okay with that?
Yes. Where was Marissa? Went back to her area? There he is. Oh.
There you just saw Popple. And Joe, I agree with you, but I also hope and think that highlighting it and people calling it out and how horrible it is, hopefully that creates some change. I really do. I hope so. Let's highlight the bad ones so we can get them out.
Thank you very much.
Thank you.
So we have like a chain of custody. Wherever you want to go to get the evidence. You can go to the interview. It's fine. Sure. I can fill out a
Wherever you want to go to view the evidence.
statement or something. Witness statement. I'm a witness.
And I need to give a statement because I'm a witness.
I'm called here as a witness. To the Rust trial.
I called here as a witness to the Rust trial. So how do we know it's connected to Rust? He was on the witness list for the Rust trial and he brought what he said was evidence. Come on. There's no way we could ever think it was connected to this Rust trial. Let's put it in a different file.
And I live in Arizona, so it's a long way.
The other thing that's also annoying is if I brought a sock to the police station on a normal case and I said, this is evidence in that file, even if they found it was not evidence, they still would have put it in that file.
I got it. 22. The last minute, he said, okay, I want you to testify. And then we didn't want the other.
Okay.
Well, I don't want to run this evidence forever.
That's fair, but you guys are not.
Yeah, I don't care what you do, I just don't want to have it. And they're 45 cartridges. Like,
They're from the set?
He said, I don't care what you do with it. I just don't want to have it. Somebody asked, are they from the set?
no.
Okay.
And he says from the jump, they're not from the set.
Do you want to know the details?
Did you hear what the gentleman said?
Yes.
Was he asked if they were from the set?
Yes.
What was his response?
No.
So, okay, if we're going with that and we're just going to believe whatever he said they are evidence in the Rust case. They're not from the set, but they are evidence. Are we only going to believe some of what he says? Doesn't work like that.
Or do you want me to
Well,
write it down?
let me start with, what is your name, sir?
Troy. Oh, that's a great start.
Troy, for what?
Troy Tesky. T-E-S-A-E. I've got all kinds of identification. You should see I'm a
Were you getting called by?
retired police officer.
By the defense, yeah. But they didn't end up using it. Okay.
Here's my police ID. And then I'm also judge. You need to see that.
Also,
Okay, so they're gonna have you bring 45 rounds?
Yeah, and at the last minute.
They talked to
The
her
defense.
on the phone. You're good, they said that they're gonna have somebody for the, which they never do. Okay, so he brought it out here just in case.
This is my story.
Okay, but they don't want it anymore.
Sir, do you recall this conversation?
Yes, I do.
Do you know when Mr. Teskey is talking about being called as a witness in the Gutierrez trial, do you recall which side he was being called by?
I only learned that when he identified that.
What side?
On the defense side.
And when he said that he brought ammunition, but they didn't want to use it, was he referring to the prosecution or the defense?
I can. Is there any basis to know that?
Well, if he doesn't, I'm assuming he'll tell me.
I believe it's the defense.
so the defense knew about the witness, knew about the ammunition. That's all confirmed, right? So how will this affect Hannah Gutierrez Reed's case? It depends on if they knew what the prosecution did with it and whether or not that shows the prosecution's bias.
Anyway, yeah. They told me to. The defense attorney said, hey, why don't you bring them rounds? And I thought, and 2 times, Hancock and then Morrissey. Hancock first said way back on November 5th. And
He mentions Hancock and Morrissey by name. So they both knew he existed. Come on.
November 5th, 2021, which was a week after the shooting. Seth Kinney called me. You know Seth? Everybody seems to know Seth here. But, Seth, he was a friend of mine. And Seth Kinney
He was a friend of mine.
called me from Hancock's office. She was a detective at the time. And he said, you're on the record. I want to know what's going on with you. Because I have these rounds from, it's the same batch. They came from Joe Swanson.
Okay.
Know him too?
I know other.
That's
I've
awesome.
dealt with this case a lot.
Okay. You're the perfect person to what's your first name?
Marissa.
Marissa?
Yeah, I apologize. I'm the crime scene technician.
All right, well, I better jot that down. I have some good notes on it. So when my big concern was having these, they said, okay, I said, I have these these rounds. I have a batch, a whole bunch of rounds,
Okay.
or a bunch. And then they, I said, well, you probably don't want me to send you the whole batch. You want me to just pull something out and send you a picture. So I took a picture with my phone, sent it to Seth, and he was in the office with Hancock. And they looked at it, and Seth said, "Yeah, this is evidence from the accidental shooting." The accidental,
And you
yeah.
say they're from the same batch of
Yes.
live rounds?
Yes.
Okay.
It's if you know the case, Bell Reed had a whole bunch of live rounds.
Yes.
And they, Seth and Fell, went to Yellowstone 1884, 1883, and he was teaching people how to shoot with these rounds.
Right.
Then they left there and they went together from Arizona, and then they came back and went to another set, which was.
Sir, why does your video end there?
Because I walked out of the interview and was attempting to, or I did contact Detective Hancock to see who this individual was and why he was there turning in evidence like he called it.
Okay.
So like he texts Hancock, is like, hey, what's going on? Explains everything. He thought the evidence was tied to the Rust case. Hancock was unavailable. Defense questions then are just basically repeated what was on the video. Then Morrissey takes the stand. But first, somebody gave me another. Erlinda asked to approach at 5:20. So let's go to 5:20:46. 5:20.
All right. In the thousands of times you've done that, that would mean.
I'm sorry, Your Honor, Ms. Johnson's asking to approach.
Ms. Johnson's asking to approach. Okay. So that was very clear. And I remember hearing that. And then 5:22:50 is when she walks out. Oof. I mean, Morrissey's just got to know it's over then. The court reporter even looks a little surprised. All right. So that's probably when it happened. Thank you for giving me those timestamps. All right. Now we're going to get to Morrissey testifying. And I'm going to start playing it. I'm going to go refill my water as we listen, and I'll be right back. So here we go.
I do.
All right, go ahead.
During my investigation of this case and my review of the evidence in this case, I came to understand that there was a large batch of live ammunition that was in the possession of Thel Reed, Hannah Gutierrez's father. I also understood from all of the evidence and testimony that a portion of that batch of ammunition that belonged to Thel Reed was taken by Thel Reed and Seth Kinney to the 1883 cowboy training camp. When that was over, leftover ammunition was taken back to PDQ props. Seth Kinney took some of the ammunition from that container that he had brought back from Texas and turned it into the sheriff's department. And it appeared to me that he did it to try to exonerate himself. They took it from Mr. Kinney and they tagged it into evidence under the Rust case. Law enforcement then executed a search warrant at PDQ props and they took the entire container. And I will say that I do agree, as I recall, although I don't have it in front of me, I do agree that the search warrant didn't really require law enforcement to take everything, but it was my understanding that Mr. Kinney gave them everything so that they would have it and could tag it into evidence. Portions of that ammunition were then sent to the FBI for testing so that they could be compared to the live rounds that were found on the set of Rust. The FBI testing demonstrated that the live rounds that were taken from PDQ props that were originally in Texas did not match the live rounds on the set of Rust. And that's testimony that we heard during the Gutierrez trial. So what ended up happening was Mr. Bowles, Ms. Gutierrez's lawyer, put Mr. Teskey on a witness list and was intending to call him as a witness to the Gutierrez trial. I conducted a pretrial interview of Mr. Teskey, and I want to back up. I did at this point have some understanding that Mr. Teskey had had contact with law enforcement regarding these rounds that he still had in Arizona. So these are rounds that never left Arizona. They were always in the possession of Thel Reed and Troy Teskey. They never went to Texas. They never came to New Mexico. That's what all of the evidence indicated. So I understood that Detective Hancock had communication with Mr. Teskey about trying to get those rounds, and Detective Hancock was unable to get those rounds from Mr. Teskey. I did not find that particularly concerning because those rounds had never left Arizona. The filming of Rust was in the state of New Mexico. And the rounds that were taken from PDQ went from Arizona to Texas to Albuquerque. So
what's also interesting about this, like we remember from the Hannah Gutierrez retrial, there were all these like loose ammo and rounds and bags and refilled, and you can make a live round, a dummy round, and we heard all of that. So if it's a box that matches ammo that was on the set, this ammo doesn't have to actually be on set for it to be relevant, or at least potentially relevant.
Ammunition that is in the state of Arizona that has never left Arizona did not strike me that it had significant evidentiary value.
So
then
you made the decision as prosecutor, I'm not turning it over. And this is how much power prosecutors have. Somebody asked a question. Paul said, please explain why Seth Kenney isn't on trial here. He supplied live ammunition in the first place. Because prosecutors have the power to make those decisions. I don't know if I think people are starting to understand how much power a prosecutor has. Jag, Carrie M appears so smart, Peter. Why would she do something that seems so obviously prosecutorial misconduct? In my opinion, people can get out over their skis if you're not grounded in certain morals and ethics and making sure you don't come close to the line or do things that's like not a big deal, like speaking objections that you can argue in front of a jury that, you know, maybe you'll get away with it a few times until somebody stops you. If you're willing to do stuff like that, usually as a lawyer, you get the opportunity to push the line. I'm actually speaking at a conference next week, a lot about ethics and morals and the morality of what your worldview is and how you practice law through that worldview. And if honesty and integrity and morality and truth and justice are part of your worldview, then to me, that's the best kind of lawyer, because there's so much parallel with what we're taught, what we learn, what we're tested on in ethics and professional responsibility, that it makes a big difference. And if you have somebody that's willing to cut corners, you may like it, you know, when it's your case or when it's working well for you, but when it blows up in your face, it doesn't look good. Even smart, good lawyers sometimes mess up.
Oh, and I will say, I believe I actually saw a photo of it. At that point in time, I was able to look at the ammunition myself, and it was visibly dissimilar than the rounds from the set of Rust.
The judge disagrees.
We then cut to November of 2023. Mr. Bowles has put Mr. Teskey on a witness list for the Hannah Gutierrez case. We conducted a pretrial interview with Mr. Teskey on November 2nd of 2023. At that point in time, he brought up that he was still in possession of these live rounds that were Thel Reed's live rounds that had never left the state of Arizona. I then, when he started, I think he indicated during the pretrial interview that they were from the same batch that was sourced from Joe Swanson. And I then said, we should get those from you. I had a conversation with Detective Hancock after that pretrial interview about how we could get the rounds from Mr. Teskey, and we were trying to figure out if we could send a local law enforcement agency to pick them up. I was then decided that I needed to figure out if that was necessary since they had never left Arizona. And up to that point, it was my impression that they did not match the live rounds from the set of Rust. I then, as I recall, reached out to Mr. Bowles. He and I had a conversation about whether or not the rounds should be tested by the FBI. And I was still trying to figure out if I could get the rounds from Arizona to New Mexico. So I asked Mr. Bowles to please send me a photograph of the rounds from Troy Teskey so that I could see with my eyes whether they were even remotely similar. If they were similar, I could go through the steps of obtaining the ammunition, connecting probably with local law enforcement, having a local law enforcement agency go to Mr. Teskey's residence and collect them. I didn't want to do that if they didn't look anything like the rounds from the set of Rust, because all 6 rounds from the set of Rust are identical to each other. So when I had this conversation with Mr. Bowles, he provided me the photograph that I showed this morning. And this is it was my understanding that this was a photograph from Troy Teskey. So Troy and I don't communicate. He's a defense witness. I can't communicate with a defense witness. So Mr. Bowles, as I recall, texted.
It's not actually true either. Like you can't, there are plenty of different ways you can communicate with a defense witness.
Me this photo, and this is a photo that Mr. Teskey took at my request so that I could determine whether this ammunition was related in any way to the set of rust, because it never left the state of Arizona. So if it never left the state of Arizona, the only way that it is relevant to the rust investigation is if it has any similarity to the live rounds that were found on the set of rust, because we were at that point trying to figure out the source.
It's not true. Like, that's just not true. It could at least be potentially relevant if it matched even the dummy rounds. If live rounds match dummy rounds, there's arguments that you can make that Baldwin would have never known, and see, it could have been these live rounds, which would have been live, but they would have looked exactly like the dummy rounds, and he wouldn't have been able to know. There are arguments that can be made. And here's the point, happy at heart. If she would have turned all this over, does it mess up her case? Maybe, maybe not. That's the most annoying part. It's not like it was a smoking gun that they had to hide. It was just them abusing their power and not even letting defense attorneys make arguments. That's the worst part, honestly. Deb N. What if something similar happened with Koberger? How do we prevent this and improve our legal system with good prosecutors and judges and law enforcement who take their oath seriously? That's how you fix this. Pay attention. Everybody pay attention to your own jurisdiction where you live and vote and pay taxes.
Of the live rounds. When I received this photograph from Mr. Bowles, I could immediately tell that these are very dissimilar from the live rounds that were found on the set of rust. They have brass.
I have a question. Why did you need to send the live rounds and the dummy rounds to the FBI to be tested at all? If you could just tell by looking, why test anything?
Primers. So this is what was presented to the prosecution as the rounds that were in Mr. Teskey's possession. They have brass primers and not silver primers. One of them, the one on the left, appears to be a Starline brass casing, but they have truncated cone projectiles. We had seen ammunition that looked exactly like this, not exactly, but very, very similar. And that ammunition was the ammunition that was collected from the sheriff's department and went to the FBI for testing and was determined not to be similar in any way to the live rounds on the set of rust.
So why'd you need to send them to the FBI?
So when I saw this photograph,
there's just no doubt they handled this evidence differently than anything else. And Spyro even said with some of the other witnesses, it's like, well, you did this follow-up with this evidence. You did that. You put this evidence in the file. You made this report within 24 hours, but none of that did you do here. You followed up with witnesses that ignored your calls, but you didn't do that here. And it was a pretty good argument. So Mary Smith saying Helena's family will never see justice. So Hannah Gutierrez-Reed was convicted. So if that's what they need for justice, then potentially they got some justice there. But what I'll say is, from everything I've read, and I could be wrong, and I don't know the Helena Hutchins family at all, it seems like they worked together to come to a good result to the civil cases. And there was at least less animosity. Some civil responsibility may be taken to where they felt like they got some justice there. I'm not sure how hard they were pushing or pressing for criminal charges. I kind of have heard it on both sides. So I still think the civil justice system did provide them some justice that they agreed to.
I could see that it was not at all similar to the live rounds on the set of rust. And I decided not to take any steps to collect this ammunition because it was in Arizona, had never come to New Mexico, and didn't match the live rounds on the set of rust. So what ends up happening is Mr. Teskey is called to New Mexico by Mr. Bowles to testify at the Gutierrez trial. And you can hear on the video that the court heard Mr. Teskey say, the defense attorney, that's not me, asked him to bring samples of that ammunition. According to Mr. Teskey, he brought the samples of the ammunition, showed them to the defense attorney, and the defense attorney said, I don't want those. I'm not going to use those. And by the way, I'm not going to call you as a witness. So Mr. Teskey sat in court during the trial, and then at some point contacted the deputies downstairs and said, I have this ammunition. So he tried to give it to the defense attorney, who's the person who asked him to bring it. The defense attorney said no. And he then tried to get a hold of Detective Hancock, who was not available because she was with me. So then he ends up going to the sheriff's department and he leaves the ammunition at the sheriff's department. I was contacted, I don't think it was the same day, but I'm not 100% sure. It's possible that it was, by Detective Hancock, and she indicated that Troy Teskey had dropped off ammunition at the sheriff's department. Because I had already asked for a photograph of it, I believed that that ammunition was going to look like the photograph that Mr. Bowles had sent me. Corporal Hancock indicated that she was going to tag them into evidence and she was going to create what she called a doc report. And I said, great, do that. I was not aware at that point in time that a doc report would not have the same case number as Rust. I was not aware at that point in time that it would not be linked to the Rust case number.
That's kind of the only thing that she does to kind of throw some of the law enforcement officers under the bus, to say like she didn't know that it was going to be documented that way or put in a separate file, or that law enforcement was going to handle it that way.
I understood that he had dropped off ammunition that I believed to not look similar to the ammunition from the set of Rust. And I had no idea that it wasn't going to have the same case number. I want to show the court, though, when Mr. Teskey showed up to testify with the ammunition that Mr. Bowles told him to bring to the state of New Mexico, he was not called as a witness, and Mr. Bowles said, I'm not taking that ammunition from you. That's why. Because these are photographs from Hannah Gutierrez's cell phone extraction, and they show spot-on match for the live rounds found on the set of Rust. This is clearly the reason that Mr. Bowles said, you and your ammunition better get out of here, because it would not have hurt the case, the state's case against Hannah Gutierrez. It would have been the best evidence I could have hoped for.
Does anybody believe that? I think that's total BS, because if that's the truth, you would have brought him in. And federal calligraphy, they paid for the gun manufacturer. They paid for Mr. Pieta to come from Italy. So if that would have been the best evidence, I think we can all agree, they would have brought it in. Like, come on. Come on. Tiffany said, Peter, what would you ask Morrissey under oath if you had the chance? Honestly, the one big question would have been, Ms. Morrissey, at the end of the day, you looked at this and you didn't feel in your discretion you should turn it over, right? Right. You didn't care if anybody would disagree with that discretion, right? Right. That's what I would ask her. You did this with your power and your discretion. You didn't give anybody else the chance on the defense side to determine whether or not it was exculpatory or probative or anything. Accidental jurist. I was surprised at the fact that IO had asked TT to send that ammo previously to her, but then when he hand delivers it, it's not evidence. You didn't even have to pay to bring it over, because guess what? He brought it over to you. So is OJ Baldwin done with criminal trials and just facing possible civil lawsuit for wrongful death? I think he's settled most, if not all of them. I'm not sure if there are still civil lawsuits out there. SR, if the witness, yes, he's done with criminal. He's done with the crimes connected to these set of circumstances. If the witness is admitted to lying on the stand, didn't the DA suborn perjury? Incidentally, I feel like Lally is also suborned perjury. So again, if they didn't know it, you didn't know it was going to be a lie, things like that, it's very different than knowing somebody's going to lie and you ask them a certain question. So we got to figure out who knew what and when. That's the harder part. I said, better analogy, nurse injects a patient with placebo handed to them by doctor, kills the patient because it wasn't placebo. Who's at fault? So we'd have to look at duties there. Definitely the doctor. But I've seen like the pharmacist who fills a bottle and gives it to the tech and gives it in. And I mean, there's all sorts of questions. And that's why duty is so important. Whose duty is it to do what? That's why we have experts. Azam, did the jury receive dismissal news Monday or the day of yesterday? I would say yesterday. They probably reached out to all of them. They have their contact info. Would Morrissey prosecute Hannah if she's retried? Highly doubtful, I think. But I don't know. I don't know at this point. Regardless of mixing and custody of bullets, who was ultimately responsible for the safety and protocol of checking those rounds before using? We know Hannah was responsible for a lot of it based on her trial. Unfortunately, we didn't get to see the experts in this trial. Peter, what's the benefit of hiding this, Tara? Well, good lawyers on the other side, you don't want them to come up with something that may be convincing to the jury. You just don't want to give them any more tools potentially or any more bullets in the chamber. Stephanie, what was so frightening about this evidence to make the prosecution want to hide it in the first place? Again, I think she did a good job of explaining it in front of the jury with the witness on the stand, but sometimes you get out over your skis and you make really bad decisions. Meg, given Morrissey is a special prosecutor, is there more that can be done from a disciplinary point of view, or is it more that she's less likely to be another gig as a special prosecutor? Yeah. Could it have an impact at her own firm? Sure. And she could still get sanctions or certain things that any lawyer could, whether you're a prosecutor, a special prosecutor, or a defense attorney. Miss Melanie. Peter, do you think trials being on camera / social media are making people behave this way? People have behaved this way for a long time. There's a lot of bad lawyers, unfortunately. How long until she has her own YouTube channel? I don't know about that. I definitely think that's different and people are more interested in it. And there's definitely more lawyers getting on YouTube and things like that. But I think it's highlighting lawyering. And I think people are going to not understand what good lawyering is. You don't have, like, even people were saying it about Spyro. His presentation doesn't seem that smooth. It doesn't seem that great. Good lawyering is not all about presenting. It's a lot about digging. It's a lot about investigating. It's a lot about credibility. Like, I think he has found to me to be incredibly credible. Everything he has said has been true. He hasn't pressed the lines. He's been respectful. Same thing with a lot of other lawyers that we've really liked on here. But it's not always about, how you look, or like Jackson, like the way he presents in his expensive suits. I think that's cool. I like that. I like watching that. But it's not always the same, and good lawyers can look and act differently.
These look exactly like the ammunition, the actual ammunition that we have in evidence. And they do look like the 3 rounds as them at the sheriff's department to try if there was any relevance at all. And so that we could get some idea where they came from, what the relevance was, if there was any relevance at all. And he never returned her phone calls. And that's all of the information that I can give the court, but I'm happy to answer any questions.
Can I ask a few questions, Ron? When you took over this case, the investigator handling the case, Mr. Schilling, left the case, correct?
At my request, yes.
The paralegal that was handling this case with you left the case, Mr. Tad.
At my request, yes.
Well, the first prosecutor that was working with you on this case, you selected, correct?
I did.
And he resigned too?
I wouldn't say that he resigned, no.
Okay. He didn't stay on the case for the Alec Baldwin trial, correct?
No, and he indicated that that was because he represented a labor union, that's a national labor union, and he was not expecting the trial to be set so quickly. He wasn't expecting it to be set in July. So when he realized that the trial was going to be set in July, he was going to be in collective bargaining agreements for his national labor union, and he wasn't going to be able to have enough time.
Erlinda Johnson, the next prosecutor selected, resigned from the case today.
She did.
So that's where we got the news that Johnson resigned from the case in the middle of this. And we're going to watch her interview. So we're going to focus on what she did and what she was thinking more when we watch that. But that's not great.
In part on the conduct we're here discussing, correct?
So Katie said same argument could be made for the gun destroyed. But guess what? They told exactly what happened. They turned that over. I agree with you. I think that's a really good argument for the defense, but the state could argue against it. That's how it's supposed to go. You turn it over and we deal with it, and the jury finds out what's true and what's fair. But you can't bury stuff and hide stuff.
I believe that Ms. Johnson Ms. Johnson didn't want my understanding is that she didn't agree with the decision to have a public hearing.
On July.
So she said, I think my understanding is she didn't want to have a public hearing. Johnson's going to respond to that, but she didn't guarantee it. She didn't say for sure. So it's hard to prosecute that type of stuff for perjury. SJ, please help me understand. Since Baldwin case was dismissed due to the prosecutorial misconduct, will this affect Hannah's case or any other case Morrissey was the prosecutor on? Will there be a federal probe? So no, it's specifically this case mostly. Hannah's case potentially could be affected if there were similar issues or buried evidence or things that Bowles can connect and make it like it was not a fair trial. I don't know the answer fully to that, but they're not going to dig into other cases, I wouldn't think. I don't know if she was a special prosecutor on other cases. It would be hard to prove this stuff at this point in other cases. This is pretty specific to this case. Again, how will this affect Hannah's case? How will it impact Murdaugh? I'm not sure anything in this case will impact Murdaugh. Maybe stuff in the Karen Reed case you were talking about. Murdaugh's lawyers could probably look at that and make some similar arguments.
First in this matter, you served a certificate of compliance with 5501, correct?
I did.
And you've never turned over the report or any of the evidence that we're talking about here at this hearing, correct?
Let's take it one at a time. I did not turn over the report. I didn't have a copy of the report.
But did you know the report existed? Because if you knew it existed and you just never asked for a copy, that's just you not doing your job.
Rounds that were left at the sheriff's department by Troy Teskey, I have absolutely no reason to believe that they are relevant to the incident that took place on the set of Rust. These are rounds that were in the possession of Bell Reed and never left the state of Arizona.
You also did not allow the defense to view that evidence at any point during our request to review evidence in this case.
I had never seen it, and I didn't realize that it was.
So I'll tell you what else I like about Spyro. He is not fighting with her. He's being calm, cool, collected, and she is looking a little like she knows her pants are on fire, you know? Caitlin, that's so cool. That's awesome. And I wish you good luck. If I can do anything, let me know. You got any questions or anything like that? Shoot me an email, come on streams, and continue to put your questions in here and I'll answer whatever I can.
Wasn't under the same case number because I'm not a law enforcement officer and I don't work at the sheriff's department, but you are right.
And you concede that they are Starline Brass Silver 45, right?
I can. And this is the best evidence against Hannah Gutierrez.
Yeah, you said that a couple of times. Any favorable evidence
You
you
said that a couple of times, but you didn't decide to bring it in her case. Okay, cool.
understand as a prosecutor has to be turned over to the defense,
I
correct?
do.
Any evidence that could be used as a defense to potentially be favorable has to be turned over to the defense.
Absolutely.
So the third Hague report that never got turned over to the defense, you understand that that's Brady evidence?
I did, yes.
Okay. And you also failed to
There's even more. Again, this is not one thing, and that's the problem. And she's a defense attorney, so she knows this.
turn that over in this case as well, correct?
And let me give you a full answer to your question. When the second Hague report came in, and I provided all of this to the defense, there was a problem with it. So I then appeared that the former paralegal who was working for the special prosecutor had removed it.
So she blames other people basically for why some of this stuff doesn't get turned over, but you can't do that when you take over the case as the prosecutor.
So we then immediately provided it. Then during the pretrial interview of Mr. Hague, it was brought to my attention that the defense did not have the August 31st report that indicated that the gun functioned fine, perfectly fine. And that was provided immediately. I went back, I checked my email, I could see that I received it from Mr. Hague and failed to forward it on to be uploaded. And I provided it as soon as I was aware that you did not have it.
The fact that nobody at the Hannah Gutierrez retrial cross-examined Mr. Hague about the report didn't clue you into the fact that nobody had the report?
Actually, it didn't, and I'd like to address that. The reason that it didn't clue me in is because Hannah Gutierrez's defense was that the gun worked perfectly. The defense in Hannah Gutierrez was never interested in any evidence that there was an issue with the gun, because if there was an issue with the gun, it damaged her case. So what you could see, if you watched the trial or saw any of the transcripts, the defense actually brought in their own expert to say that the gun worked perfectly. So they had no interest in that information.
And actually, you elicited testimony from Mr. Hague at that trial that was inconsistent, at least partially inconsistent, as the court's aware, with his third report, correct?
Tell me what you're referring to, and I'll answer your question.
Well, there was a whole hearing about this where you saw this, and you saw me go back and forth with Mr. Hague for 25 minutes. So
I agree, but I need to know what you're talking about for me to answer your question.
Okay, if you can't answer the question, you can't answer the question. I'll move on.
I'm happy to, but
This is him knowing he's winning, so he doesn't need to waste his time.
You say that the extent of the
kind of side eye look at the judge, like, Judge, what do you want me to do with this?
communications you have about the doc report, as you relay it to the court, is that all you said in response was, "Great, do that." That's your testimony?
yeah, I assumed that it was going to be tied to the same case number. So I said, great, do it, file a report.
No follow-up questions?
Again, pointing the finger a little at law enforcement there for sure.
No, because I had a picture of the ammunition that didn't match the ammunition from the set of Rust.
No concerns in your mind when you got the case file and you turned it over to us that it wasn't included?
Absolutely not. There's a
Barf. Like, that is just the worst. She should never be a special prosecutor again. Whoever asked that other question, you're right. And maybe they should look into other cases. If this is how she handles it, I mean, this is horrible. That you don't even care. You literally don't care if you turn everything over or not. And this is why, okay? And people get mad at me depending on the case, and depending on the defendant and the crime, and I get it. This is different than the Brian Koberger case and you know, whatever. But like, this is why I get frustrated when prosecutors do stuff like this, because then when they get caught, this is how they act. They're like, no, never thought it was a problem. I didn't find it relevant. It's like, that wasn't the question.
there's a terabyte of discovery. I didn't know whether this 2-page police report had been provided. And in addition to that, I had no reason to believe, and still have no reason to believe, that those rounds have anything to do with these cases.
As I asked you about Mr. Hague yesterday when Ms. Popple testified, you would agree with me that her testimony under oath was false.
What part of her testimony was false? And I'll answer.
That she said that these rounds don't look anything like the rounds on the set when you elicited that testimony.
I agree with you. And I didn't realize that there were rounds that looked like that.
It's okay. In any event, when the court, and you never
But like, she's agreeing her own witnesses were wrong, and she didn't realize. And I mean, that's an excuse for perjury, but it's not an excuse as a prosecutor that, oh, I didn't realize that there were rounds on set that match that. And that right there, that answer right there is why you turn everything over. Because as a human being that's fallible and makes mistakes, all of us do, you might not think it's relevant. You might not see how a lawyer could use it. But if it's even potentially relevant, just turn it over. If you don't think it could match anything, you could be wrong, just like you admitted you're wrong here in the crime scene tech and investigators, and they were all wrong.
tested those rounds either, correct?
Any of the rounds that came from Mr. Teskey? No, because they came in just a few months ago.
And the court asked you actually one question that I want to address, which is the court said to you, well, what's interesting to me, to be quite honest, is that yesterday you didn't even want to do a written reply. You wanted to just give an oral response. And what you said to the court was, I never saw these. I've never seen these. And I never saw the report. I have absolutely never seen these until this morning. Do you remember saying that to the court?
With regard to the 3 Starline brass, with regard to the 3 cartridges that appear to be similar to Rust, yes.
Well,
I'd never
So I don't know. I feel like her demeanor is the same as it always is. I don't really notice a difference in her demeanor.
saw them until today.
Well, but you said also, I never saw the report, right?
I never did.
Right. But don't you think, given your duty of candor to this court, that that's awfully misleading to not tell the court at that point that you knew about this when it occurred long ago?
That I knew about what?
You knew that Mr. Teskey had turned in this evidence, that you knew that the report would have existed because you just told this court that the doc report was okayed by you.
Sure.
Don't you think it was misleading to this court to not just say at that point, just so you know, I know about this. I knew about this then. I was involved.
I did not intend to mislead the court. My understanding of what was dropped off at the sheriff's department is on this computer screen, and it looks absolutely nothing like the lag rounds from the set of Rust.
The truth of this matter is, you don't like Mr. Baldwin very much, do you?
That is absolutely untrue. I actually really appreciate Mr. Baldwin's movies. I really appreciated the acting that he did on Saturday Night Live, and I really appreciate his politics.
You told one of the witnesses who disagreed with you during an interview that you thought Mr. Baldwin was a cocksucker.
I do not recall saying that. I know that that was something that Mr. Baldwin would say on the set of Rust. I don't recall saying that.
Do you deny that under oath?
Without having more information, I can tell you that I do not recall ever saying that. And if I did say it, I invite you to point it out to me.
You called him an arrogant prick to another witness.
To who? To what witness?
I'm asking you, did you call him an arrogant prick during a witness interview?
I don't believe I did. I don't recall.
Do you deny that?
Without knowing what you're talking about, all I can tell you is that I can't respond if I don't know what you're talking about.
And you said also to
Here's him trying to get at her motive, obviously, for doing this.
witnesses that you would teach him a lesson.
I never said to witnesses that I would teach him a lesson. Absolutely not. In fact, Mr. Spyro, I want to give a full response to your question. I made every effort in this case to resolve this case with your client in a very favorable way for him.
All right, I'm going to move to strike this.
That's for the cameras. I tried to resolve it very favorably for him, meaning offer him a great plea deal like Hall's, no jail time is what she's indicating. We never knew if it's true or not. He cuts her off. But guess what? This doesn't make you look any better. Trying to force and strong arm somebody into a plea deal when it's your case is getting dismissed. Kudos. Isn't lying under oath a crime? Yes, but it's harder to prove than people think. Tim, does literally everything count as evidence, i.e. every anonymous tip, false confession, Tom, Dick, or Harry making a claim? So it's potential evidence. And a lot of things get turned over in a case, just so you know, or turned over in discovery that are never used. That's why we have rules of evidence to see what comes in at trial is very different than what's disclosed. And yes, a lot of things that are very irrelevant get disclosed and they get dealt with later.
This is not responsive.
It is responsive. I don't want to talk about plea negotiations.
Yeah, and it's not.
You're not
responsive. So
supposed to.
I have no further
Do you
questions.
have any follow-up testimony? Thank you. All right, argument, let's not, it's 15 minutes aside.
She's like, okay, now argument. And the defense is like, not necessary, judge. Go ahead and make your ruling because we all know where it's going. And this is the judge's ruling.
Why I'm seeing what I'm seeing. So in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teskey gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence. Even
the judge agrees. And when she says it's favorable to the accused, I think she means potentially favorable because we don't know what a jury would decide.
Been offered in this trial as impeachment evidence and is potentially exculpatory to the defense.
So yeah, the impeachment stuff with law enforcement, all that's definitely favorable to the accused.
Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material.
So, Nikki, if I'm understanding your question correctly, I think it's because they didn't know about all this stuff until yesterday.
The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state. Quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld the supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, pursuant to Hancock.
You can tell as she's reading her reasoning, so many of her questions connected up with this. I watched her rambling testimony yesterday, but nothing prior. How was this new evidence brought to light? We really don't know the answer. Some people think Bowles. The co-counsel for the prosecution quit in the middle of the hearing. Do you think you would do the same if you were put in the same situation? Probably. I don't know what she knew and when she knew it, but we're going to watch her interview. I would say probably. If Spyro knew before trial of burying the ammo by Morrissey and law enforcement, do you think this motion is sportsmanlike gamesmanship or sandbagging? Completely fair game. Completely fair game if he knew about it before and they were hiding it from him, in my opinion. They cannot do that. And it's not a defense attorney's job to do the prosecution's job for them. It's not a defendant's job to do the prosecution's job for them. Do you think everybody resigned because of her arrogance in bringing this case no matter what? My guess is people resigned because they didn't want the tarnishment to come back on them. That's my guess. Please watch the Jensen Ackles interrogation. It helped a lot. Okay, I have not seen that yet. So basically, she brought the case against Baldwin, hid evidence, and when caught, tried to cut a deal with Baldwin before it was dismissed. We don't know exactly what happened in plea negotiations, but that's kind of what it sounded like.
Testimony that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper?
It is literally crazy to think about cases getting dismissed like this. It is so unusual. It's shocking. It shouldn't happen. And that's why I said, knowing this was coming for the prosecutor to then not dismiss the charges again, this is an indictment against the prosecutor. She does not agree with this. She could have taken steps outside the judge's control. The judge cannot force a prosecutor to keep going. If the prosecutor's like, we're done, judge, we're not going to prosecute the case, the judge can't say, no. You can't quit. I'm going to fire you. The judge can't do that. And they still push to get to this moment.
Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated, State versus Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
Granted, folks. And what's to come next? To understand what, malicious prosecution is, which I think is what's going to come. And we've had some cases like this. So this is in Florida, that the defendant, which would be the state, the government, initiated or continued a trial against the plaintiff, which would be Baldwin. The original lawsuit or legal proceeding was without valid cause, right? That's going to be the tough one to prove. The lawsuit ended in favor of Baldwin. That's going to be easy to prove. And the defendant, the government, acted with malice or improper purpose in initiating or continuing that proceeding. And the plaintiff suffered damage or loss. So a couple of those will be difficult to prove. A couple of them will be easy to prove, but it'll be really interesting to follow. And this is the correct legal result, but was justice served? In my opinion, yes. This will help so many other cases. This is what justice is. If we can break the rules because we think the bad guy got caught, that's not justice. And by the way, this was far from like a guaranteed conviction. There were ways I think the prosecution could win. There were ways I think the defense could win. So with this many mistakes, I think this is the absolutely just result. That's my opinion. Stupid question. Could the Karen Reed team use this, especially with all the BS Lally pulled? Thank you for everything. I don't really think much of any of this applies to the Karen Reed case specifically. Felt like the ending was unrealistic and jumped the shark. Prosecutor on the stand. I was half expecting Spyro to arrest Morrissey as everyone clapped. It did feel a little bit like a movie. Rebel Duck. Okay, Peter, what exactly did the judge have time to type up this ruling while Kerry was on the stand? Quick as ready whip. Have a good weekend, y'all. I think it was during that long break. I think everybody knew how this was going to go for a while in that courtroom. I really do. Does the Teskey ammo matter because they're from the same live 1883 bat? Again, listen, I don't know if it mattered or not, but you still have to turn it over. That matters. Those rules matter. And the defense, there have been plenty of cases we're watching and we don't know as well as the defense. And the defense makes a good argument where we're like, wow, okay, I didn't think about that, or I didn't know that existed. They have to be given the opportunity to make those decisions. Isn't this exactly what's going on in the YSL trial? Like even worse, I think. I think even worse. But I also think there's a lot more evidence against those defendants, which is why people are slower to do this stuff, which, again, it sucks, but the right decision needs to be made. All right, let's jump over now to Ms. Johnson's interview on News Nation. And we'll take a listen to exactly why she quit this case. We're on 2 hours. This will be the last part we read or we'll listen to. Thank you, everybody, for joining. Thanks for hanging with me. Hit the like button if you haven't already and subscribe if you haven't already. We are going to watch this whole interview here to let her explain herself and from her perspective what was going on with somebody that, and this is also unusual for her to come publicly make statements like this.
Thanks for taking the opportunity.
Hi, Chris.
First, let me give you a chance to respond to what was said about you. Another member of the team said you left the team because you didn't like that this Brady hearing was public.
Absolutely not. Absolutely not. I left because I learned about this evidence when the public learned about it yesterday, late afternoon. I don't know if you're aware, I actually came on this case kind of late in the game. I came on the case towards the end of April. So I had to get up to speed. I was not involved in the Hannah Gutierrez case at all. And so I was not aware that this individual had taken this ammunition to the sheriff's department and provided it to the officers. I learned all of that yesterday when Mr. Spyro was cross-examining the crime scene technician. So I inquired some more. And this morning when the motion hearing began, my position was during the lunch hour, before the lunch hour, during the lunch hour, we have an obligation as prosecutors. We have an obligation not only to the people, but to the defendant. Mm-hmm. And our obligation is to make sure that all the evidence is turned over. We don't get to decide what the defense is going to be. Our job is to ensure transparency and to ensure that the defendant has everything that the prosecution has gathered.
I mean, she comes with it. She's right. I would love to see her on the other side of a case that I was defending criminal defendant on. I would love to see her as a prosecutor because I would trust that this is what she's going to do, that she's going to turn everything over and we can let the case be decided on the facts and the evidence that should be before the jury. And it's not because I think it'd be an easy trial or I think she's bad or anything like that. I want ethical people on the other side.
What they do with it, that's up to them. Go ahead.
Two things. One, the better minds that I bring on the show, because what do I know, were very impressed by your opening. They felt that you had good command and that you made a very strong case. Did you believe that Alec Baldwin should be found guilty?
I did. I believed the evidence that we had. I had no idea that there was this other evidence.
She better believe that if she was going to prosecute it. So again, I agree with her answer here. She should think that if she's going to prosecute him.
Had not been turned over. That there were some actions that were done during the filming, and there was some recklessness. I did based on the evidence that was available. But my job is not to get a conviction. It's to put the evidence before a jury. That's how I saw my job, is to put all this evidence before the jury and let the jury decide. But once things start, go ahead.
No, I want to hear you. But once things what?
So once I learned that this evidence was not turned over, that it was there, it was under a different case number, and my obligations, my ethical obligations as a prosecutor. Now, keep in mind, I've been a prosecutor. I was a state and federal prosecutor for over a decade. I've been a prosecutor. I've been a criminal defense lawyer for the last 16 years. So I've been on both sides. And I know what you're required to do. And when this came to light, I think that the best decision would have been for the state to dismiss the case. That's
100%. 100%. And by the way, if you want to know how you can save face and still look good amidst the chaos that is bad law enforcement, a case going too far, whatever, you do the right thing. She's going to come out of this looking like a hero. Morrissey is going to come out of this looking like a villain. They both were prosecuting the same case. One's being honest, I think, about when she actually found out about this stuff. One is qualifying it in a certain way to try to not make herself look bad.
That's why I resigned.
Really?
Because I believed that that case should have been dismissed. And I advocated for that over the lunch hour. And it wasn't. And so when we came back after the lunch hour,
It's their decision. Because God forbid the judge would have let the case go forward. And now you know you've committed all these violations and stepped on a person's right and you go convict them. How do you sleep at night?
I asked to withdraw.
So you wanted the prosecution team to walk away from the case. They said no. So you said, then I'm walking away. And then the judge basically agreed with you. So I have two questions. First one is, so you believe it should be dismissed? Explain to people who don't understand anything about the law. Why did you believe this ammunition was so important for the defense?
So obviously, you're a lawyer, I think. Brady versus Maryland imposes requirements on the prosecution to turn over evidence. The rules of criminal procedure impose those requirements, those duties as well. So is the evidence material? That's number one. How timely is the disclosure? Without question, this was grossly untimely. Number two, is it material? So the question is, could the defense have made some use of this evidence in their defense?
And she's explaining it does not have to be the smoking gun. That's the point. And Mary Smith, I think this is a good comment. If it's worthless and it's not even that bad, it's even worse that you would bury it. And it almost proves you would bury stuff if you could. That was important, right? Ethan said Johnson opened the case. Johnson closed the case. This interview. Boom. I love that. That's like dropping a hammer. Thank you, Ethan.
And like I said, we as prosecutors do not get to make that decision what the defense is going to be. It's, can the defense use this and could it potentially raise some sort of reasonable doubt? And you have to step back. You're not an advocate. As a prosecutor, you're not an advocate. You are there to present the fact.
You are an advocate, but I get what she's saying. She's saying like, you're not just there to convict, you're there for truth and justice.
And to present the evidence. And your job is, and that's why I took this case on. I agreed to come on board, is because there was a woman who was killed. No question about it. This was tragic. And something happened. And a jury needed to make that decision. And so I believe in the system. And unfortunately, something went horribly wrong here. And I was not aware of it. And when I did become aware of it, my ethical obligations dictated that I advocate for a dismissal.
So Olga, she's saying that she left as soon as she found out about it. So she didn't know about it on Wednesday. She didn't know about it until yesterday, which I agree with. The defense didn't know about it until yesterday either. So I think that's plausible.
So let's talk about what went wrong, okay? And you guys at home can Google Brady versus Maryland. It's a 1963 case that basically just goes to things that either could be exculpatory, meaning it's evidence that the defense could use to show it wasn't them, or what they call impeachment, which is evidence that the defense could use to show that one of the witnesses for the prosecution is full of it, okay? Basically, that's what Brady was. They call it Brady material. Your co-counsel says you have it wrong, that this ammunition, she knew about it, obviously, and she says, nah, it didn't have any real value. It had no resemblance to the ammunition that is involved in Alec Baldwin's case. Why would I turn it over?
Well, at the end of the day, a jury could have believed that, but our obligations are to turn all evidence over that could potentially be used by the defense in their defense. It's not for
potentially is a big word, okay? And as you guys know, to lawyers, words are important and definitions are important. And that potentially word means you don't get to choose. You don't know how I would have used it. You took that decision out of my hands. Blake, I honestly don't know the answer. I don't know who's going to do it. Kay Lisa, Peter, sorry this is a stupid question, but why would a state be so hell-bent on bringing a case if the case is not strong? I don't know that the case was not strong. That's the question. Maybe they thought it was really strong. It's all of these mistakes that create the issues. I don't know that anybody is saying or admitting that their case wasn't strong. We didn't really get there.
for us to decide what is the defense going to be. It's not for us to say, well, his defense was he didn't pull the trigger. So his defense
I
is
got
not.
you.
he
I
didn't
got you.
break
But here's the tough question. Here's the tough question. The suggestion, not from you, from me, is that this may have been in bad faith. Your co-counsel knew about this. She was willing to get on the stand, take the oath, and say, I didn't see any value here. Defense counsel and you echo the same standard. You don't get to decide whether or not it has value. She says, yes, I do. Otherwise, how do I know what to turn over? And I thought this didn't meet the standard. What is the standard, and why do you believe co-counsel got it wrong?
Well, this is a lot to process. Obviously, I learned about this yesterday evening. But just in looking at, so the first time I look at this evidence was this morning because it was brought over to court. I think as you saw, the judge had them open the envelope. And so there were 3 rounds that looked very similar to the live rounds that were found on the set of Rust. Thinking as a defense attorney, I'm thinking the defense could have argued Hannah Gutierrez-Reed was a great armorer. She was completely competent, and there was sabotage. So you have that potential sabotage angle. So then at that point, potentially those 3 rounds do become potentially exculpatory.
And we've heard that argument made in other trials, right? Like we've heard that argument made.
But the point is, it should have been turned over. It wasn't turned over. And
you think it met the standard? Any way you look at it, it should have been turned over. It was enough for you to step away. I want to ask you about the case now that it's dismissed, because I didn't understand why you guys brought it. I thought it was totally political. I thought if this.
So before she gets into why she brought it, Mel said, I have nothing but admiration for people who are ethical. And Mel, I agree with you. And I will tell you, everybody thinks and says they're ethical. And it's really easy to say you're ethical and talk about how you've been ethical in the past. What's really hard is to be ethical when nobody's watching, and be ethical in situations where you don't think anybody's going to know or anybody's ever going to find out about it. And I will tell you, law enforcement, lawyers, and judges have that opportunity almost every day. And they have to choose and they have to decide, am I going to be ethical? And it usually doesn't happen overnight if the answer to that is no.
This guy's name wasn't Alec Baldwin. If it was Alec McIntosh, he wouldn't be there. That he pissed off the prosecutors early on by what he was saying and they wanted to get him. Why am I wrong?
Well, first of all, I was not involved in the charging decisions. I will tell you that based on my evaluation of the evidence that I was privy to and that I saw when I came on board on this case, was that there were numerous clips from the filming on the set that showed that Mr. Baldwin, unfortunately, did engage in some horseplay with this gun. For example, one individual who was interviewed by the OSHA investigators and testified or gave an interview that there was a time that he allowed Mr. Baldwin to use him kind of as a target to shoot blanks at him, at his person. And obviously, these are real guns. You don't do that with real guns. So there's
on a movie set? But isn't that exactly what they do on a movie set?
Well, no, you don't use another person as a target, as a human target. So that could potentially be reckless. And so, he wasn't charged with intentional homicide. There's no question, for me, there's no question Mr. Baldwin did not intend to do this. But the question is, was there wanton and recklessness? And so that's why I did believe in the case. I had no idea that this other evidence.
In the beginning, we didn't think he could be charged. As we heard more information from the FBI testing about, did he pull the trigger? Did he not? Did he lie about that? We thought, okay, maybe. I could see how this would go either way. It's not the strongest case in the world. Hannah Gutierrez-Reed gets convicted. His case goes to trial. There's a chance he could get convicted. Is it fair? Should he even be on trial? Those types of questions are out there and are okay. But when you violate the rules, we don't get to get there. And Kita Gee, I agree with you, but let's also not forget, we've seen a lot of good judges, a lot of good prosecutors, a lot of good defense attorneys also in these cases we've streamed and followed together as well. So I think it's good to highlight what people are, right? Some of them good, some of them bad, but we need to know that it is out there, that there are unethical prosecutors and judges and law enforcement officers and defense attorneys.
Had not been turned
Right.
over.
That is very clear, and I've told the audience, this is not about you. That's a separate prosecutor who seemed to know about it. We've showed her on screen. Her name is Morrissey. It is not you. I just want to ask you, I have 2 more questions. The first one is, I still don't buy it. I don't understand how on a movie set, you should have a reasonable expectation that you might have live ammo in the weapon. Well, why? Why would you have that as a reasonable expectation?
Because remember, there are the SAG guidelines, there's bullets and safety bulletins that dictate, even if you're an actor, even if you're on a movie set, you treat a live.
And unfortunately, we didn't get to a lot of this in the trial and hear what the 2 sides experts would have said to be able to compare that and see where we fell or where the jury would have fell.
a real firearm as though it's always loaded, never point it at another person, and don't put your finger on the trigger until you're ready to shoot. Those are cardinal firearm handling safety rules. So yes, did I believe that there was some inappropriate behavior with regard to handling this gun? I do. It's unfortunate that things went the way they went, but the fact of the matter is that we as prosecutors have very, very serious and high ethical obligations that when something comes to our attention, evidence comes to us, or we become aware of evidence, you turn it over. You don't decide.
Are you a big Alec Baldwin fan? Are you a big Alec Baldwin fan?
You know, I actually do. I am a fan. I wouldn't say a big fan. I never saw him as Alec Baldwin, the actor. To me, this is the case. Someone died. This was a tragic case. Someone was killed. And she was killed with a live bullet. She was killed because someone also pointed a gun at her. I never had, for me, it was not about Alec Baldwin, the actor. This is not about politics for me. It was about putting forth the facts before a jury.
Last thing for you, and again, really, thank you for coming on, Ms. Johnson. Really appreciate it. You ooze authenticity to me, and we are very hungry for it right now when it comes to trusting our institutions. So I appreciate what you did, but I'm also worried for you now. Are you worried that, you know, the right move was for you to just kind of sit there and let the judge make the ruling, and then if they made the wrong ruling, you could have walked away, but now you walked away and you may be a target in the community or by other prosecutors for going bad on your team?
Well, no, I walked away before the judge made the ruling. I asked you.
I know. Should you have waited?
No, absolutely not. I have ethical obligations. And personally, I have moral obligations. And my ethical obligation and my moral obligation.
Does she seem worried to you? She doesn't seem worried to me. She seems very confident and competent. And lawyers are going to stand behind her. Lawyers are absolutely going to stand behind her.
Really are not that different. And so when I see that something isn't right, and when I see that the law isn't followed, I don't care who you are, where you are, you make the right decision. And for me, the right decision was to walk up to the judge and ask to be allowed to withdraw before that circus of a hearing got underway.
Do you think that she decided the way she did because of you?
No, absolutely not.
Wait.
Absolutely not. I think that.
My opinion, no.
I got to tell you. Go ahead, make your point.
No, I think it's because it met the legal standard.
I got to tell you, Erlinda Ocampo Johnson, this is a very refreshing conversation. It has nothing to do with the outcome of the case. I still don't get the case, but I respect your argument on it. And I really respect what you did and your rationale for doing it. This was a brave thing to do. And I have tremendous respect for you. And if there's anything we can do down the road to help, if this gets a little ugly because people don't like what you did, we're a call away if we can help in any way.
Yeah, I mean, she's kudos to her. I ride with her, you know. RS said, how is Morrissey going to argue Brady as a defense attorney in the future? She could have preserved justice for that, for the state defendant and herself, but chose this. I'll just tell you right now, most lawyers like this have no problem turning around and arguing something completely differently. I've seen it happen. Casey Cat isn't the guy who brought in the evidence a former judge. That's what people in EDB chat were saying yesterday. So he says that on the body cam footage that he was a former officer, judge, things like that. I don't know that about him. I'm not trying to be annoying, but she does say twice yesterday evening, yesterday evening. This was on Friday, I think. So yesterday evening would have been Thursday. I don't know the answer, Olga. I don't know the answer. But in my opinion, she says she bounced as soon as she knew and as soon as she could not convince them to dismiss the charges. It's not like she bounced at first glance. KR trial. I did not mean to put the other comment up. Sorry. KR trial equals craziest trial. Baldwin trial. Hold my beer. JK, I still believe KR was the wildest case maybe ever. Oof. All right. It's a long one. Hit that like button, please, if you guys have not already, and make sure you subscribe and hit the reminder bell. I don't know what's next. You guys tell me what's next. I'm sure there's going to be fallout to these last couple trials we've covered. I'm going out of town for a couple days, but I'll probably be streaming from wherever I'm at. I appreciate you guys so much. I appreciate the questions and the comments and taking the ride with me. It was a short one, but we made it. The roller coaster is probably close to over, but not totally over yet. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.